Lordships. We are before your Lordships to challenge the deeply flawed and impugned judgment of the trial court in the OS number 124/2024 dated on the 20th December 2025. The appellants have approached this Honorable High Court by invoking Section 96 of CPC. If your Lordships may permit, may I state the facts of the case? Much obliged, your Lordships. Your Lordship, the core question before the Honorable Court is simple yet profound. It is, can a mere subsisting legal formality outweigh the lived reality of the family that existed in substance, emotion, and economic dependence? My lords, this case reflects the conflict between strict legal formalities of a marriage under Hindu Marriage Act and the modern reality of long-standing domestic relationships and the functions as family in substance. My lords, the present dispute concerned is about 4 acres agricultural property situated in Panja village, Sullia Taluk, consisting of 3 acres of ancestral property and 1 acre of self-acquired property, valued approximately around 1.2 crores, which Rajiv inherited from his father in the year 2021. Your Lordship, Rajiv married the respondent Sukanya in March 2015. However, within a year, in April 2016, she left the matrimonial home and never returned. For nearly 8 years, there was no cohabitation, no contribution, and no assertion of matrimonial rights from her side. Thereafter, Rajiv began living with the appellant number 1, Madhvi, from 2019 onwards. They lived together as a family, maintained a shared household, and their son Ajit was born in 2020. This relationship was openly recognized by the society and supported by the document records as well. Your Lordships, unfortunately, Rajiv died interstate in February 2024 in a road accident, and it was only after his death, smelling that 1.2 crores windfall, that the respondents reappeared and obtained a mutation of entire property solely in her favor on the basis of a 10-year-old marriage certificate. The trial court further denied any recognition to the appellates despite the long-standing domestic relationship and an existence of a minor child, Your Lordships. Your Lordship, the respondent relies only on a technical existence of a marriage certificate while ignoring the reality of 8 years of abandonment. The appellants will purely show that the law cannot be applied so mechanically as to deny the protection to the woman and child who lived as a real family in every practical sense. If your Lordships are well versed with the facts, may I move on to the issues and arguments?
Yes.
Much obliged, your Lordships. The very first issue, whether the marriage between Rajiv and Sukanya, though subsisting in law, continues to govern succession rights despite the prolonged separation without matrimonial proceedings. Your Lordship's first sub-point is, subsistence of marriage does not confer exclusive entitlement to all rights. Your Lords, we fairly...
Under which law? Under which law?
Hindu Marriage Act, Your Lordships.
No, under which provisions is?
Section 5 and under provision... The exclusive entitlement you are asking for, Your Lordship.
Now you have pointed out, under which provision of Hindu Marriage Act? It says about this.
Shall we reframe? Whether the wife will be entitled for the
Your Lordship,
estate
Your Lordship,
or the living-in partner?
I'm not able to hear you, Lordships. Can you pardon the
Sorry,
question?
whether the wife is entitled for the estate or the living-in partner.
Your Lordship, it depends on the court how to examine or how to take...
Sorry, what is the law?
The law says...
Law of the land.
Your
Law of the
Lordship,
land.
the appellant humbly submits that we agree that there is a legally wedded marriage happen between the deceased and the respondents, Your Lordship.
Abandonment will kill the relationship of husband and wife.
Your Lordship, the reason is not...
Abandonment of any of these spouses will end up in the matrimonial tie automatically.
Your Lordship, the divorce process, the desertion is maintained for 24 years, Lordship. After that, you can be taking a claim to the court, and then from a competent court, you can be obtaining a decree, Your Lordships.
I have deserted for 100 years. Whether the matrimonial tie will end.
In the statutory law, it has been clear.
Whether the mere desertion will end the matrimonial tie.
Yes, Your Lordships.
Yes, sir. Which provision?
Under which provision? That's what we are asking.
Your Lordship, the desertion...
Is there any provision under the Hindu Marriage Act which will say if a spouse abandons the companion, automatically the matrimonial tie would come to an end?
It will be a ground for divorce, Your Lordships. Here, neither party have initiated. Your Lordships, but we have to consider...
Is there any provision is what is being asked?
Under which provision that you are now arguing?
Under the Hindu Marriage Act,
Yes, Your Lordships.
is there a provision whereby one can say that if a spouse abandons the other spouse or deserts the other spouse, matrimonial relationship will come to an end automatically?
Your Lordship, there are ground for divorces. In that, desertion is a ground, Your Lordships.
Ground is okay. You have not gone, she has not gone.
Okay, Your Lordships.
In the meantime, one of the spouses die.
Yes, Your Lordships.
Her relationship vis-a-vis the dead person is that of the wife, which continues to be the wife.
Yes, Your Lordships.
The opposite party whom you are claiming, is only a living-in partner.
Yes, Your Lordships.
Living-in partner cannot be equated to a wife. So with that, we are proceeding with the rights of the parties, right?
Yes, Your Lordship.
Now, the brother wanted to find out what is the provision which would allow a living-in partner to lay claim onto the estate of a deceased. This is the simple core issue that is to be looked into.
Yes, Your Lordship.
Hope you are clear, we are clear.
Your Lordship, one more core issue is to whether find that...
No, that
Madhvi-
first let us see this core issue, no?
Yes.
Who are you? I am the legally wedded wife. Who are you?
Sir, the 8-year-long...
At the most, you are entitled for the maintenance when the fellow was living.
Yes, Your Lordships.
Not beyond that.
But looking,
Yes.
looking at
All
the
right.
minor-
All right, you go ahead. So, we will now understand
Yes,
that
Lord.
there is no provision under the Hindu Marriage Act wherein in the subsistence of a first marriage, the spouse cannot get any right. Now, further, you have a small child also, then look at 17 of the Act
Yes, Your
and then see whether the child can get any right, illegitimate child will get a right in the property left behind.
Your Lordship, that is section 16 of Hindu
Yes,
Marriage Act.
yes, 16.
Yes. And after the Revan Siddhappa distinguishing, it has been very clearly stated about the minor child.
𝐾𝐗𝐫𝐻𝐿, then Revan Siddhappa, ancestral
Bharat
property, then individual property. We are now concerned with the individual property. Therefore, 𝐾𝐗𝐫𝐻𝐿 will hold the field, not Revan Siddhappa.
Yes, sir.
Even Revan Siddhappa reiterates the 𝐾𝐗𝐫𝐻𝐿.
Yes,
Go
sir.
ahead.
Yes. My lords, we fairly concede that under section 5...
No, sir, we made your job simple.
Yes, Your Lordship.
Don't get
No,
put
sir.
up. Don't
No,
get
no,
put up. We made your job simple by restating the few facts which you wanted.
The council
You
learned
can
from...
go ahead.
The council learned
Now,
from the
this
Lordship.
time 1 or 2 minutes you will have to exclude. Yes.
Much obliged, Your Lordship. We fairly concede that section 5 and section 11 of Hindu Marriage Act, a second marriage during the subsistence of a first marriage is clearly void. And admittedly,
There is no marriage at all. Second marriage, don't say.
Yes,
There is
sir.
no marriage at all. Only
Yes.
living in relationship.
Living in-
You can have 100 such relationships.
Yes. Your Lordship, the respondent in the fact sheet itself, the respondent deserted the matrimonial home in April 2016 and never resumed the cohabitation or asserted any matrimonial rights thereafter. In contrast, the appellant number 1, who cohabited continuously with the deceased from 2019 till 2024, maintained a joint bank account and was publicly recognized as wife and bore a child acknowledged by him. These facts clearly state and establishes a stable and continuous relationship in the nature of marriage and not a mere casual association.
Yes.
Your
Now-
Lordships, I would...
Now, just a moment. Any amount of any period of cohabitation, will it be equated to marriage?
No, Your Lordships. It will
That's
be
all.
only...
Go ahead. Yes.
Your Lordships, as in the fact sheet, it has been very clearly stated.
Fact sheets
No,
are
no,
there, sir.
it is
Fact
different.
sheets are there.
Yes, Your Lordship.
We are only trying to find out
Yes.
what is your understanding of the law.
Law.
Right?
Yes, Your Lordships.
Just because I had the relationship for 10 years, I begotten a child, bank accounts are mutated, will it grant right for you to those properties is the simple question. If it is so, under which law?
You are in appeal. Now you are in appeal actually.
Yes, Your Lordships.
That's why go to the question of law and answer.
Yes, Your Lordships. Much obliged. Your
Yes.
Lordships, I would like to point out a mythological substance, the concept of dharma patni, flows through a shloka during the ceremony of marriage, which states that dharmecha, atecha, kamecha, and nati charana.
Kamecha.
Amecha.
Kamecha.
Sorry, your lordships.
Kamecha, not kamecha.
Amecha, your lordships.
Kamecha.
Amecha.
Kamecha.
Kamecha.
You're a bachelor now.
Your lordship, this clearly states that in dharmecha, the religious duties must be fulfilled, the financial struggles must be seen, the desires and the physical needs must be fulfilled, and the wife says that I will never live by against your side.
Yes.
Then
Now, a living-in partner, can she be a dharmapatni?
Your lordship, the interpretation of the word.
No, sir.
Yes.
There was no interpretation whether a living-in relationship
Yes, your
or a concubine
Yes, your lordship.
or a second wife
Yes, your lordship.
or third wife, fourth wife, fifth, so on and so forth.
Yes.
Could they be termed as dharmapatni, or the one who is called Maharani or the dharmapatni?
The one legal wedded wife, your lordships, will
That's
only
all, no?
be called as
Yes.
dharmapatni.
Yes.
But what are the
all
duties?
all others are called upapatni.
Upapatni. Yes.
Right. Fine.
But the interpretation which I was stating
Upapatni,
is the Sukhan.
wait.
Yes, your lordship.
Upapatni,
Your
mythology has now taken.
Yes.
Mythology on one hand, yes. To substantiate your arguments, agreed, no problem.
Yes, your lordship.
But upapatni cannot be a dharmapatni at any given point of time.
Here the council seeks
You
to
also have the mythological story of Dhruva,
Yes.
Suruchi,
Yes.
Suniti,
Yes.
Uttama, Uttanapada, Dhruva. Right? Yes, go ahead.
Much obliged for this knowledge, your lordships. I would like to state a case of, in page number 17 of the memorial, your lordships, in Channamunia versus Vijendra Kumar Singh, it has been clearly stated that we are in the opinion that the broad and expansive interpretation should be given to the term wife to include every those cases where a man and woman have been living together as husband and wife for a reasonably long period of time. And strict proof of marriage should be a precondition for maintenance under section 125. As it has been termed.
Yes, you are right. Supreme Court was dealing with a situation
Yes,
where one person had only one living-in partner,
Yes,
not
sir.
the wife.
Yes, sir.
Right? Here you have a wife vis-a-vis the partner.
Here the Supreme Court.
Now
had
the case is also on question of 125 CRPC, which is a social piece of
it
legislation.
can be only taken for persuasive value, my lordship. Just the dicta
No,
of the.
It is binding so long as
Yes.
you want to claim maintenance. That's with the bench clarified in the beginning itself.
Yes, your lordship.
So property rights are something different than the maintenance rights. Right?
Yes, your lordship.
Agree?
Agreed, your lordship.
So
But-
property rights.
It can be
Property
only
rights.
taken for the persuasive value, lordship,
you-
not
you-
for
you-
the whole
you-
judgment,
you-
only
you-
for the
you-
dicta.
You can also reserve this for the rebut. Let the
Done.
other side answer.
Done, your
Because there is an issue with regard to revenue entry as well.
Yes, your
Right?
lordship. Yes.
Okay.
In the
Revenue
very-
entry, when it comes for that, you can rebut it. Otherwise, you will be giving the hint to them.
Yes, your lordship.
Okay?
Done.
Take it.
In the D. Veluswamy case, it has been submitted that the expression subsisting wife, subsisting marriage has been judicially understood as a technically legal status and not a conclusive determinant of all civil consequences. The Honorable Supreme Court has constantly distinguished between a de jure marital status, which is a legal form, and a de facto marital status, which is the social reality. I draw your lordship's attention to the Supreme Court's water wash ruling.
This is also under 125 CFPC. Cannot
Your lordship,
equate
the
with,
facts of the
right-
case.
Right of the aggrieved.
Yes, your
The
lordship.
125 with the
Property
so far as
rights.
The property rights. It's already my lordships have said.
There are no cases with the exact facts same.
It
to the,
can't be because that is the law. Yes.
Your lordships,
It can't be because of that is the law of the land.
Yes,
So there cannot be any decision which goes against the law of the land.
Yes,
As simple as that. See, we should accept.
Yes, your lordship.
You should accept and move on.
Yes, your lordship.
Now the case is also here. If you see the prayer in the suit, the prayer in the suit is not for maintenance. It is for the property rights.
Yes, your lordship.
So property rights,
Succession rights.
inheritance or succession. These are the only two things.
Yes, your
A
lordship.
property cannot be ownerless, therefore inheritance will kick in.
Yes, Your
If you are claiming under somebody a right which has been possessed by that particular person by way of succession, then Section 6 of the Hindu Succession Act will apply.
Yes,
If
sir.
it is an inheritance, it will go to Section 8 of the Hindu
Succession
Succession
Act,
Act, right?
1956.
So these two things must be very clear in your mind.
Yes, Your
Now we are dealing with the situation of Section 6, not
Section
in
6.
8,
Yes, Your Lordships.
right? Yes, go ahead.
Okay. I draw your Lordship attention to the
And
Supreme.
also one other point,
Yes, Your
there
Lordship.
is no inter-vivos difference here.
Your Lordship,
What is
pardon?
inter-vivos?
Yes.
That is not between the two successors, the issue is not there.
Yes, Your
It
Lordship.
it is between the two separate individuals on the basis of the relationship that the deceased had.
Yes, Your Lordship.
That's all.
If Your Lordships may go to para number 8, the doctrine of purposive interpretation favors the recognition of the substantive relationship, Your Lordships. It is humbly submitted that statutory provisions, particularly dealing with the social welfare and family relations, must be interpreted in the purposive and liberal manner so as to advance the cause of justice rather than defeating its adherence to the rigid technicalities. Your Lordship, the doctrine of purposive interpretation requires the court to consider the object and the social context of the law. The narrow focus on the formal marriage would defeat the right of the woman in a long, stable relationship, ignoring the contribution and unjust enrichment of the respondents. My lords, the personal laws cannot be applied in a rigid manner that causes injustice. They must be aligned with the constitutional values of fairness and dignity. Where a woman and children are involved, the court must adopt an interpretation that reflects lived realities and advance substantive justice rather than denying the protection on technical grounds.
So you want to say Constitution would recognize 10 living in partners against the rights of a wife, is it?
Your Lordship, it will then invoke for judicial legislation.
No, I am only trying to find out if your argument is
Yes, Your Lordship.
that the Constitution mandate requires 10 living in relationship partners as put against the legally wedded wife.
This relationship comes under the nature of marriage, Your Lordships.
No,
Marriage-like relationship.
no, that is what we are trying to tell you.
Yes, Your Lordship.
At no stretch of imagination, a living in relationship cannot be equated to marriage. If it is so, then there need not be any other aspect at all. Then Section 5 will come into picture, whether the marriage could be a valid marriage.
Yes, Your Lordship.
When what are the requirements for a valid marriage?
They should be age of majority, no spouse should be living. They should be attained age of majority.
Then-
no spouse should be living at the
No spouse must be living in. That is the first requirement. So now the spouse is there. What prevented that gentleman who died in a road traffic accident to obtain a divorce, stating that my wife has left me, abandoned me for 8 years, so she has deserted me. I have other requirements also. Biological compulsions want me to have another companion, so I want to marry. He could have obtained the divorce.
Your Lordship, that was fault on the both parties. Both didn't.
No.
approach the court.
Now you see 13.1a.
There was no efforts from the respondents.
No,
as well.
sir, 13.1a, 13.1 capital A. If you obtain restitution of conjugal rights and if you don't come or if she doesn't cohabitate, each one will get the right of divorce. That's amended long back.
Whether there is presumption of marriage under law?
Under Indian Evidence Act,
There is any
119.
provision of presumption of marriage?
Can you presume?
Whether you can presume.
Presumption of marriage and under the course of natural events, under in section.
Is there a presumption is the question. Simply say no.
No, Your Lordship.
Then why don't you answer straight
Your Lordship,
away?
if I say no, it will directly conflict with
No.
the argument.
Then we assess you that you are fair. Otherwise you are trying to hide something.
Your argument must be based on law.
Yes, Your Lordship.
You should apply the law to the facts.
And secondly, brother is reminding you, you are in appeal, 96 powers,
Yes.
reappreciation of factual and legal aspects of the matter, you have already suffered.
Yes, Your Lordship.
Your appeal itself is not maintainable is what they are going to say.
Yes, Your Lordship. Your Lordships, the complete abandonment by the respondent dilutes her claim also, Your Lordships. Paragraph 13.
All right, now you are asking for the other lady, the living in partner. What is her marital status, please?
She's also married, Your Lordship.
What about her husband?
It has not been stated in the facts, and facts are silent on that. Sorry, Your Lordship.
If she is a married wife of somebody, how can be a wife of somebody who is dead only for the property, is it?
There has not been considered about the spouse or married wife, Your Lordships. They were in a
Sir,
relation.
sir, she was married means it is means what? She is wife of somebody.
Wife of somebody.
If wife of somebody, can she be a wife of another person who is dead only for property rights?
And, the long cohabitation doesn't.
No, long cohabitation means what? She is cheating her husband and this lady also, no? And is that what the Constitution wants us to recognize? That you cheat your husband, then come for the property rights for a widow?
No, Your Lordships.
Then what do you mean by liberal interpretation of Constitution?
Your Lordships, it clearly states about the desertion with the first
Sir,
wife has done-
desertion is agreed, sir.
Yes, Your Lordships.
Desertion is agreed. 8 years she did not have the company. Therefore, this gentleman wanted to have a relationship with another's wife.
The marriage of Madhvi has not been defined in the facts, Your Lordships, and
But she is a married, no?
that has been mentioned, Your Lordships.
No, that has been mentioned means what?
Then it.
Tell me the definition of wife and husband. Tell me that. He should say because he is the one who has approached the court and there is a suppression there. Yes, yes.
The council will get back to Your Lordships on this.
You don't know who is wife?
No, wife. The legal.
No, I want a simple explanation, simple definition of husband and wife, that's all.
The legally wedded spouse, Your Lordships, in the registry.
Sir, what is the definition of a wife? Why reception ceremony is made, you know?
Yes, Your Lordship.
Why?
To make-
Have attended any wedding reception?
Yes, Your Lordship.
Why?
I think to.
Enjoy, better dressed, go there,
No, Your Lordship.
greet the couple, come back, have a nice buffet.
To recognize the.
To tell the rest of the world, till yesterday this lady was available and now she is married, therefore all of a sudden the figure that you are all enjoying has become your Bobby.
Yes, Your Lordships.
You could have married her, no? Your friend has married now, so what your friend will say? Henceforth don't look at her like that, she is your Bobby. Right?
Correct,
Means
sir.
what? Means what?
The
No, I am
recognition-
going to the legal issue. It may look like, ordinary example. I am going to the legal issue. Means what? When your friend says she is no longer freely available, she is now mine, and your Bobby, means what?
It comes under the legal protection that no.
No. Henceforth, she can't marry any other person. And she can't be the wife of somebody else also. Right?
Yes, Your Lordships.
So means what? An exclusive property that has gone to one person, right?
Yes, Your Lordship.
Why I use the word property is, the body of the female is considered to be her property, and you don't even have a right to look at it. Forget other things. That's what the Honorable Supreme Court would say. See, the argument was there, she was not properly dressed, therefore it made me to rape her. What the Supreme Court said then? Even if she is fully naked, you don't have right.
Yes, Your Lordships.
That's the way, that's the level of the respect you should have for the others. So you are a married person, you have cheated another lady, you had a relationship with another married person,
Your Lordship.
so you cheated your husband, you cheated another lady, you also want to have the property of the deceased.
Your Lordship, it is not, I want to rephrase it, it is not cheating, Your Lordship, it is finding a suitable home where.
You should have obtained divorce, sir, from your husband.
Your Lordship, the council states that the fault was at the both parties, that they didn't approach a competent court, Your Lordship.
Therefore, fault means what? No place for the faulty person to have an advantage. Nobody can take advantage of his own wrong. That is the law, no?
But Your Lordship, the long cohabitation and the minor child.
Why did you have? Why did you have in the first place? Now you want to make emotional blackmail stating that the child is there. Child it will get.
Yes, sir.
Illegitimate child will get right. Now that is not the case. Case is for what? You want to exclude the legally wedded wife and claim the entire property rights for you. Child will get anyway one share. The wife of the deceased wife and the child will get half. That's all. That too in the whatever the property that has been
Self-acquired.
self-acquired. That's all.
Yes, your lordships.
She can't be a widow of one man and wife of another.
See,
I heard.
see the senior saying there cannot be dual relationship that you are a wife of one person and widow of another person. Good, sir.
True words.
Continue.
If your lordships are satisfied with issue number 1, may I move on to issue number 2?
Yes.
Whether the long and continuous cohabitation between Rajiv and Madhvi raises a presumption of valid marriage under section 19 of Bharatiya Sakshi
Already
Adhiniyam.
discussed. No, brother said no presumption. Yes, next point. Next point,
Sir,
please.
as I'll just quote the exact words in the statutes.
No statute is there. If you have long cohabitation, you will become a marriage.
Your Lordship, section 19 clearly states that the court may presume the existence of any fact which it thinks likely to have happened regarding being had to be common in the course of natural events, human conduct, and public and private business. Here, Your Lordships, it is clearly stated that all the legal indicators have been fulfilled in the facts, like publicly holding out, community integration, officially declaration as spouse, and absolute financial
May
interdependence.
is equal to what?
Sorry, Your Lordships.
May is equal to what?
It is at the court's decree.
May is equal to may not. We may not. Yes. Next.
For the purpose of
Sir, may is equal to may not.
much obliged, Your Lordships. And at last, paternity was acknowledged by the deceased itself.
No, sir, no problem on that. Paternity, the child will get a right is the issue. That don't worry about it.
It was
See,
the legal indicator, Your Lordship.
your suit cannot be dismissed in toto. Your suit is to be decreed half. Right? To what extent?
Partially it is right.
To the extent of what? To the extent of
Of
the
child.
illegitimate child.
Yes, Your
You being the legal guardian.
Yes, Your
Right.
Lordship.
Natural and legal guardian.
But it is partially convinced, Your Lordships. The,
No,
even
sir. Illegitimate child. Illegitimate word is illegitimate.
Yes, Your
If it's legitimate, automatically you will also get a right.
But section 16 clearly defines the children
Illegitimate.
from legitimate and illegitimate
What is the object of that?
to reduce the social, to finish the social stigma.
Remove the label of bastardism on the newly born child. That's the object.
Yes, Your Lordships.
You understand?
Yes, I got it, Lordships.
Whole object of section 16 was to remove the label of bastardism.
Yes, Your Lordships.
Then is there not a difference between the two, son and the so and so? Right, that's it.
Yes. Your Lordship, the prior marriage does not automatically destroy the presumption, Your Lordships. In the highest traditions of our jurisprudence, the Indian tradition itself recognizes the relationship as not a mere formality, but their substance and social acceptance. As Your Lordship said, the reception is kept for the social acceptance.
No, sir. Indian scenario also doesn't say you don't put an eye on to the somebody else's wife. Yes.
Sir, here between the cohabitation with the
No, sir. No, sir.
there were 2 years, Your Lordships.
No,
At
sir.
that-
No, sir.
Okay, Your Lordships.
Yes.
Obliged.
Go to the next point, please.
Okay, Your Lordships. In issue number 3, Your Lordships, whether Madhvi qualifies as a woman in domestic violence relationship entitled for protection, residence, and monetary relief under Protection of Women from Domestic Violence Act 2005. Your Lordship, the relationship qualifies as in the nature of marriage. Under Protection of Women from Domestic Violence Act 2000, Section 2F, clearly, paragraph number 31, Your Lordships, clearly states that domestic relationship means relationship between two parties who live or have at any point of time lived together in a shared household where they are related by consecutive marriage or through a relationship in the nature of marriage.
Kindly read 12, section 12,
Section 12, Your Lordship.
protection order. DV Act. Give the book to him, no? DV Act, Protection of Women from Domestic Violence Act. Kodappa. ಇಲ್ಲಿ ತಗೋಪ್ಪ. ಇಲ್ಲಿ ನೋಡಿ ಇಲ್ಲಿ. ಕೊಡಿ ಅವ್ರು. Read section 12.
Application to magistrate. An aggrieved party or a protection officer or any person on behalf of the aggrieved person may present an application to magistrates seeking one or more reliefs under the Act.
Yes, read those reliefs.
Provided that before passing any order on such applications, the magistrate shall take into consideration any domestic incident report received by him from the protection officer or the service provider.
Yes, sir.
And second sub-issue.
Relief you read.
The relief sought from under subsection 1 may include a relief for insurance of an order for payment of compensation or damages without prejudicing to the right of such person to institute a suit for compensation or damage for
Against whom, sir?
Sorry, Your Lordship.
Against whom?
Against two. Proviso there is a provision.
ಓದಿಲ್ಲ. You
Aggrieved
can reserve that issue argument in the rebuttal. You read
If Your
the
Lordship,
proviso.
it is about the procedural lapse you are asking, Your Lordship?
No, sir.
Yes,
Please go through the proviso and then come back. The shared residence is to be provided by the husband. He is not there. There ends the matter. Come to the next point. See, if we keep on discussing like this, the other side will get many hints from our discussion itself. Let them also argue, no?
Yes, Your Lordship.
Huh?
Your Lordship,
They cannot be so happy that, we are only grilled you. We will grill them also.
okay, Your Lordship. Your Lordship, whether Ajit...
Sometimes judges will also argue it.
Yes, Your Lordship.
Yes, don't worry.
No, Your
Keep it for rebuttal.
Sure,
Go through that proviso.
Sure, Your
Hope you have not gone through the section 12 properly. See,
I've gone through it, Your Lordship, but it states the procedural lapse
no
not
sir,
followed.
no sir, if you have gone through that, you would have not argued like this. Who is your opponent, sir?
Your Lordship,
Your
sir.
opponent is another legally wedded wife.
Your Lordship, will reserve...
Deceased wife is your opponent. What protection order she can give it to you?
will
You
reserve-
understand?
Yes,
The
sir.
whole act is for the husband and their relatives. If the relative is also responsible for the domestic violence. This lady has abandoned her husband 8 years earlier. So she cannot be a respondent at all in a DV Act. Right? Go ahead.
Your
Yes. Come to the next point.
Okay, issue number 4, Your Lordships, whether Ajit is legitimate child entitled to inherit Rajiv's property under section 16 of Hindu Marriage Act 1955, read with the Hindu Succession Act 1966. As Your Lordships have already acknowledged that Ajit will be getting a share, then I'll be reserving this point.
Yes,
for
no,
the
no,
rebuttals.
it's decreed. Don't worry.
Yes, Your Lordships.
Decreed.
My co-counsel will be dealing with the last 4 issues, Your Lordships.
Yes.
Much obliged, Your Lordships.
Bama, please come. Yes, ma'am. Mic will come down. You need not have to rise. That's it. Good. Don't be nervous. Yes, go
No,
ahead.
Your Lordship.
Yes.
Your Lordship, before I begin with my arguments, I want to comment on a point which you noted.
No comments here, please. No comments on judgment, please.
Okay, an observation I made.
Yes.
An observation I made.
Yes.
Your Lordship, a woman should not be raped not just because she belongs to somebody else, but because she is a woman. As you have mentioned.
No. I didn't say that. See, Supreme Court observed that the way woman dresses
Yes.
should not be a ground to rape her.
Yes, Your Lordship.
That was the intention with which the Honorable Supreme Court said. They went to the extent of saying, in case if she is totally nude also, like the Menake and other people came to destroy the penance of this other rishis. So, even if they try to impress upon you, you should not. That's the level of the samyama, restraint one should have.
Yes.
So this is basically for them. It's okay. She has commenced now. Why are you taking? So now the point is,
Yes, Your Lordship.
we are with you, the woman fraternity.
Yes, Your Lordship.
Today being the International Mother's
Mother's
Day,
Day.
we have all come from the womb of the mother, so we have highest respect for the woman fraternity. This is what the bench wanted to emphasize.
Yes, Your Lordship.
Second is, at the same time, the woman who is a wife of somebody tries to have a relationship with another married man, knowing fully well what are the consequences thereof, continues with a relationship for about 8 years and beget a child, he is now fighting for civil rights. I am making it very clear. Therefore, I also told your friend, in a civil suit, no application of Domestic Violence Act and all these things. Nevertheless, you are now trying to find out what? Another woman. So, hennige henne shatru. You understand now? So, with that preface, you can go ahead.
Your Lordship, I believe both the women were victim of the husband, Your Lordship.
Who made you? You should not have gone. You should have been loyal to your husband.
Your Lordship,
You should be loyal to your husband.
although that
You
is
should
a
be-
moral
you should be
obligation of a
loyal.
woman.
You should be loyal. You are dharma patni of somebody, not this man.
Yes,
Here
Your
only you
Lordship.
are karma patni, not dharma.
Yes, Your Lordship, I fully agree with you. On moral grounds, yes, it is bad of a
Not
woman.
moral. Legally also.
Legally,
Legally also. You are not a
adultery-
wife.
yes, Your Lordship.
You are not a wife. At any stretch of imagination, you can be equated that of a wife,
Yes, Your Lordship.
barring few other protections which are in the social nature, which the Constitution wanted. What happens if a living in relationship woman is deserted? If she is made to make use of her and then leaving all in her lurch, what should happen? Therefore, they said, you pay her maintenance, not with the property rights. We are concerned with the property rights. You have already suffered a decree, reasoning is there, you are in appeal. You say how the reasoning is bad in the law.
Yes, Your Lordship.
Facts are clear now.
Yes, Your Lordship.
In the law, show me what is your legal right to claim the
law,
property.
yes, Your Lordship. According to law, adultery is not criminalized. It was decriminalized. And whatever they are doing...
Adultery will not come into picture at all. Succession never say a word of adultery.
Yes, Your Lordship.
Succession, wife, children, that's all.
Yes, Your Lordship.
You are not a wife, you have a child, it is getting the right necessary half of the property.
As guardian of the child of...
That's
Raji-
all, not individually.
Yes, Your Lordship. Not individually. But
Your suit is decreed 50%. Yes, go ahead.
at 2/3 of the property, Your Lordship.
No, not 2/3.
Your Lordship,
Son, illegitimate son will take equally that with the wife and other children.
Yes, Your
Equally.
Lordship.
Equally is the word used.
Yes, Your Lordship.
Equally is the word
we
used.
do contend that
So
very...
50-50.
yes, Your Lordship.
That's all.
No,
Decreed.
Your Lordship, we also want to highlight the fact that Madhavi was the person who invested in the matrimonial home, if we consider that as a matrimonial home according to the bench. She invested in the property in the residence
Why
of
should you
Raji.
invest somebody else's property, madam?
Because she lived in it, Your Lordship. She lived with her...
She also had the pleasure of having the company. She also had the pleasure of getting a child which is getting 50%.
So did Rajiv had the pleasure of having the companionship of...
Therefore, he
Madhavi.
is denying 50% to his legally wedded wife.
Your Lordship, had he known that this would have happened, I think he would have reserved the whole property for his now wife, according to him.
Who prevented him to execute a will in favor of some third person? That is you.
That we cannot
That
ask
is
him
you.
because he has passed away, Your Lordship.
Therefore, 50%. Law envisages such a situation.
But I also acknowledge the fact that law does not only look upon law but equity and good conscience.
No. Don't be under all such impressions. What are Indian courts? What are Indian courts, ma?
Indian courts.
You will have to tell me. These are all law courts.
Yes.
Jurisprudence, first year, you should know. Indian courts are law courts,
Yes,
not the law of common law is not there.
Yes,
Equity
Your
is not there, unlike the American Constitution.
Yes, Your Lordship.
UK, you don't have that.
Yes, Your Lordship.
So no common law jurisdiction here.
Okay, Your Lordship.
Only law. So every order you will get what? Every order you will get what? You get an observation, no?
Yes.
In accordance with law.
Yes, Your Lordship.
In accordance with law, if you don't get anything, we are not here to grant anything more. It's not giving it from my pocket.
Yes, Your Lord.
Right? She should make out a legal right. That's
Yes,
legal right. If anything is there, what your friend has not stated, please enlighten us. If it is not there, you say you adopt and then close your case, wait for the
Your
rebuttal.
Lordship, the issue which I was supposed to be dealing with and I will be dealing with is whether Tehsildar's mutation order dated 15 July 2024.
Mutation order is all nothing to do with the legal right. Very simple.
But Your Lordship, we must know that trial court took this mutation
Why
order as
not?
the cognizance.
Why not? I am entitled to collect the tax, therefore mutation is made in one person's name.
Yes,
Does
Your
it become the right?
No, Your Lordship. That
That's
is
all.
what we are trying to establish.
That's all,
Your
that's
Lordship.
all. Leave it at that.
Your Lordship, because
It's only fiscal in nature.
exactly what we are trying to say, Your Lordship. Because it is only for fiscal
No,
purposes.
don't worry, ma. See, if you are, if it is in, if you are getting the right, it will be, court will directly change that. That's all. Don't worry.
That is what we are seeking in one of the prayer, Your
Provided
Lordship.
if you make out a right.
First make out a case.
Could you reframe the question, Your
No,
Lordship?
madam, please understand, mutation is only temporary in nature.
Yes, Your Lordship. Very
Right.
much agree.
If you are getting a legally any right that whereby we can grant you, the suit is to be decreed in toto, then automatically mutation entry will come to you. Mutation has got nothing to do. Now the point is very simple. Some revenue fellow wants to take the revenue from the property. He holds X is responsible. Tomorrow Y is the legally responsible fellow. That name will be entered. That's all. Mutation has got nothing to do. Mere change of entry in the revenue records would not confer any legal right to anybody other than the statute which governs the rights of the parties. That's all.
Yes, Your Lordship. We are trying to say the same, but trial court took cognizance of this own Tehsildar's order and gave the property, gave the declaration of title on the grounds of these, Your Lordship. And that is why what we are trying to rebuke. You cannot do that because only a civil court has the jurisdiction to declare the title, Your
No,
Lordship.
madam, you are wrong. Yes. Go ahead. Next. Time is up.
I have 3 more issues, Your Lordship.
3 minutes more. Yes.
Much obliged, Your Lordship. I shall move on to the constitutional part of the...
Yes.
Your Lordship. Your Lordship, I want to establish that Article 14 is violated because it manifests arbitrariness, Your Lordship. Firstly, I want to say
What
that...
Article 14? Somebody else's wife claiming right in the property is Article 14. Sorry. Yes, next.
Article 13, there is a word law.
Yes, Your
Law
Lordship.
includes personal rights. Law.
Codified, yes, Your Lordship.
Law, word law, it is mentioned in Article 13.
13.
Whether it includes personal rights.
I know that only codification...
N.V. Pushpalata.
I'll make a note of that, Your Lordship.
That's all.
And one more, Arasappa Mali, yes, 1955.
Much obliged, Your Lordship. Okay, Your Lordship.
Madam, in Indian courts, there are specific statutes which will govern certain areas. One such area is the personal laws. Right? Earlier to 1956, the personal laws were being governed to all people, all subjects of the country. In the 56, there was an idea to codify it. So that's how they tried to meddle with the personal laws, the legislature. They were successful in dividing Hindu code into 4 statutes. Hindu Succession Act, Hindu Marriage Act, Guardian and Wards Act. These four divisions, they made it. Hindu code was then made into statutory force. For the other subjects, namely the Christians and Muslims, they did not touch upon. So their personal law even now holds good for them. We have Indian Succession Act for the Christians. For as Muslims are concerned, even today, whatever Muhammad has now made it, that has been there. So there also we have 2 types of the personal laws, namely Shias and Sunnis. Right? Prophet Muhammad, whatever has been made in the form of Quran, that is the law for them even today. So now for the rest of the country, the issue came up. So the issue came up, Shabano. Then so many other issues cropped up. Only we have one idea of moving towards the uniform civil code in the form of independent thought by the Supreme Court while dealing with the POCSO Act. Right? So don't worry about our constitution. Now we have Hindu Marriage Act, parties here are Hindus. No Article 14 violation. If you get a right under the Hindu Marriage Act or Hindu Succession Act, then you will get a right. Otherwise, don't go to the constitution, you will not get even that right also.
Much obliged, Your Lordship.
Not elaborated.
With the permission of Your Lordships, could we give at least 5 minutes extension to speak? Much obliged, Your Lordship. Shall we focus on this issue or shall we move on to the next issue?
We won't speak. You speak.
Just speak.
Argue.
Yes, Your Lordship. Your Lordship, I want to focus on the 7th issue, which is irretrievable breakdown of marriage and unjust enrichment. As Madhavi has invested in the property already, she cannot get it back because this was a note, not a loan which she has taken from a bank, and that she can get it returned. Your Lordship, I want to say that we are not seeking a formal decree of divorce, but asking the court to recognize the functional death of the first marriage of Rajiv and Sukhanya, Your Lordship. Following 8 years of complete desertion and the separate lives of the parties, the first marriage exists only on paper. Modern jurisprudence, as seen in Shilpa Shailesh versus Varun Srinivasan, recognizes that a marriage certificate, Your Lordships, marriage certificates cannot be used as a sword to punish a subsisting family unit. Your Lordship, in a sense, who is the family right here? Is it Sukanya, who has stayed away from Rajiv for 8 years, or is it Madhavi, who has lived with him, has carried all the marital obligations, has a child with him, and considers him as a husband in front of the society as well as in the house? Your Lordship, we
You also deserted your husband.
that marriage shall also be considered dead
Then
according
what
to
is it?
Your Lordship.
You can, what argument that you are now trying to tell before the court emphasize, the same argument cuts you because you have deserted your legally wedded husband.
Perfectly acceptable, Your Lordship. Madhavi is not trying to seek anything from her prior husband, Your Lordship. Madhavi
No,
is
what if tomorrow he dies?
Whose widow?
You will get from there also as a legally wedded wife.
No, Your Lordship. Madhavi is
Then
a
give
woman.
Give that all that to her, Sukanya.
Yes, Your Lordship.
Section 72 of the Contract Act talks of unjust enrichment.
Yes, Your
How
Lordship.
can there be an unjust enrichment in a relationship which is per se illegal?
Your Lordship,
Per se illegal.
Your Lordship, I shall
Per se
substantiate.
illegal. Per se illegal means what?
We consider it legal,
No,
Your
madam,
Lordship.
please understand. You cannot consider anything from your angle. It is not legal or illegal.
When she lived with Rajiv,
Illegal will come into picture from the point of which particular law. Right? What does the contract mean?
an agreement between two parties, Your Lordship.
Consensus ad idem.
Yes, Your Lordship.
Next point.
Consideration.
Next point. ಒಂದೇ ಸೆಕೆಂಡ್ ಎರಡು ಕೇಳ್ತಾರ ಇಲ್ವಾ ಹುಡುಗರಿಗೆ ಏನಾದ್ರು ಗೊತ್ತಿದ್ಯಾ ಅಲ್ವಾ ಅಂತ. Vinculum juris. For the first time you are hearing.
Yes.
That's the problem.
No, marriage cannot be contracted.
That's what I was coming
Yes.
to
Marriage
that.
No,
cannot be
not an
contracted.
Hindu.
Wait, madam. You said unjust enrichment. It can be claimed under Section 72 of the Indian Contract Act.
Yes, Your
In the
Lordship.
first place, Indian marriage is not a contract.
Yes, Your
It is a
Lordship.
sacrament. Secondly, even if you want to take it, it must be a valid contract. Means what? Consensus ad idem.
Your Lordship, there must
Wait,
have been
madam.
a confusion. Yes, Your Lordship. Sorry, Your
What your lordship? You have not heard the word of vinculum juris and you want to tell the court what you want to say.
It's because Lordship's
What does
confused.
we mean vinculum juris?
The council seeks ignorance for this, Your Lordship.
Therefore, it must be a one which is capable of enforcement before the court of law. This is the vinculum juris.
Yes,
See,
Your Lordship.
why I am telling you is, forget this moot court. Between the two parties, whoever has argued, they will get the prize. That's a different issue. You should go to the basics. Which year in your law course? Which year?
Third, Your Lordship.
Third year. By this time, contract act is over.
Yes, Your Lordship.
So you have not read Palmer, you have not read Polak and Mullah, Cheshire and Fifut.
Your Lordship.
Have you read any one of these things? If
Count-
you have not read, go there today itself and read it.
Yes, Your Lordship.
Right?
Yes.
With this computation, we want to bring it to your notice that henceforth, don't go by Google arguments, AI
Yes,
arguments. Okay? Go to the books, go to the Palmer, go to the Polak and Mullah, go to the Sashir and Fufut, and then say how the contract is made. Contract can be enforced before the court of law. You are seeking now the contract, that unjust enrichment, provided there is a valid contract. Here the per se there is an illegality. For example, supari killing. All things are there. Consensus ad idem is there. Consideration is there. Act is also accomplished. I don't pay you the money after you take off my life. What do? Can you go to the court and then say seek for the money? That is called illegal contract, right? So illegal contract means it is not enforceable in law. There is a meeting of minds to take away the life of somebody for consideration by taking 5 lakhs of rupees. Now all that is over. So unjust enrichment, if you want to bring the contractual portion into the property rights, in the first place this is not acceptable because it's not a contract at all. Second is, it is an illegal contract, unjust enrichment. Rajiv never wanted you to bring in your money from your husband's place.
Your Lordship, may I speak a sentence?
Yes, madam. You are supposed to.
Yes, Your Lordship. I wanted to correct an confusion between the council and the bench.
No confusion. There is no fusion at all. No confusion.
No, Your Lordship. I beg to differ. There has been a confusion. I wanted to say that there is no contract between Rajiv and Madhavi, Your Lordship. Very much agreed. This unjust enrichment is not on behalf of Rajiv and Madhavi, but on behalf of Sukanya and Madhavi. Your
That's
Lordship.
what, madam, please understand. I am not a party to the contract at all.
Yes, Your Lordship.
Where is Sukanya in the place?
If Madhavi gets out of this house and Sukanya starts living in this house.
No ifs and buts. See, you wanted to have in good books of Rajiv to have that company continued. Therefore, you brought in money. How you brought in money, we don't know.
She works, Your Lordship. Madhavi works. She is an employee.
She is a teacher. She is a teacher.
Yes, Your Lordship.
Cheater.
So is Rajiv, Your Lordship.
You are a teacher, madam. So you should teach that if you are married to somebody, loyal to be your spouse. That should be the teaching that you should make. Not disloyal to your partner and then have a relationship with another partner who is disloyal to his companion. So don't worry about all that. No unjust enrichment. Yes, that's over. Next point.
So we can enlighten. What about Mohammedan law? It's a contract. Even on material say.
It's good. This is also just like cricket match. In the form of giving the water, you are trying to help her. No problem. ಆಯ್ತು ಬಿಡಿ ಸಾಕು, ನಾವೇ ಮಾತಾಡಿದ್ದೀವಲ್ಲ, ಅದೆಲ್ಲ ಟೈಮ್ ಕಟ್ ಮಾಡಬೇಡಿ, ಮಾರ್ಕ್ಸ್ ಕಟ್ ಮಾಡಬೇಡಿ ಅದಕ್ಕೆ. ಹೂ ಇಸ್ ದಿ ಟೈಮ್ ಕೀಪರ್? ಯು ಆರ್ ದಿ ಟೈಮ್ ಕೀಪರ್. ಡೋಂಟ್ ಕಟ್ ದಿ ಮಾರ್ಕ್ಸ್ ಫಾರ್ ಎಕ್ಸ್ಟ್ರಾ ಟೈಮ್. ಓಕೆ, ಥ್ರೂ. What happened? What happened now?
I shall argue it.
Yes, you can continue. What happened? What happened? She's any issue, health issue? Yes. You, in the meantime, you take care of her. Yes, madam, you can go ahead. ಅದು ನೋಡಿದ್ದು ಯಾರು ಸ್ವಲ್ಪ ಕೇಳಿ, ಏನಾದ್ರು ಹೆಲ್ತ್ ಏನಾದ್ರು ತೊಂದರೆ ಆಯ್ತು ಅಂತ. Yes, madam. Yes.
May it please this honorable court, this is the council appearing on behalf of the respondents. My lords, the council will be addressing on 4 issues. For the sake of convenience and brevity, all the 8 issues which is outlined under the proposition are consolidated in 4 issues, wherein, my lords, pertaining to the marriage of Sukanya as well as Madhavi would be addressed by this council, and the legitimacy of a child as well as the mutation entries by my co-counsel. My lords, firstly, before I may even begin my arguments, my lords, the council truly is concerned for the opposite counsel. However, my lords, want to make a highlight that the opponent counsel highlighted that under Hindu mythology, my lords, 𝐷𝐼𝐸𝐾𝐲 is present, wherein your lordship has also very well made a distinction where Dharmapatni as well as Upapatni is totally different. With this, my lords, with the limited knowledge of this council, the council is reminded of the jurisprudence of the Hindu marriage, wherein the very foundation of Hindu Vivaha is captured in the Panigrahana mantra of Rigveda. My lords, I stand corrected, my lords, with the limited knowledge, my lords. In the Rigveda, my lords, which emphasizes that marriage is a sacred bond formed through the various rituals and customs and the practices.
Why did you go away for 8 years without leaving a hand of your spouse?
Indeed, my lords. My lords, if I may answer this.
Why?
Please, my lords, if I may.
Why 8 long years?
If I may, my lords, I want to answer this in a way, at least, my lords, Sukanya deserted for 8 years but did not remarry, my lords. This answers, my lords, that...
See, why did you leave? See, what should
lords,
I do?
Please.
What should I do?
My lords, the respondent may not shy away from the realities of the society.
No, madam, please understand.
Maybe there is a breakdown of the...
No, you left 8 years earlier.
Indeed, my lords.
And if the Raji were to be alive, you would have been away for several years further. Only after his death, for the property, you came back to the relationship, is it?
Your lordships miserably, my lords.
No, if
Sukanya
you are so good.
Please,
no,
my
if
lords.
you are so good.
Please.
If you are so loyal, if you are so honest, what made you to come back to this relationship after Rajiv's death, only for the property?
My lords, because the court of law assigns this
I am
right.
only trying to understand you, who you are.
My lords, I am Sukanya.
You are Sukanya.
I was
came to
deserted
know.
for a period.
You left the company 8 years earlier.
Indeed, my lords.
If the Raji were to be alive for some more time, but for his unfortunate death in the road traffic accident, you would not have seen to this particular property again. If you are so loyal, if you are so honest, give the entire property to the other lady.
Indeed. My lords,
Entire
if I may
property you
answer
give
your
it to her.
lordships, please, my lords, if I may answer, my lords. Law does not ask why Sukanya left, my lords. It only asks whether she remained in a legal relationship, whether such a marriage is in subsisting. Please.
That we are
That
aware
answers,
of.
my
No,
lords.
that we are aware.
Please,
You
my lords.
wanted to portray that Sukanya is so good. After leaving also, she did not remarry.
Indeed, my
Therefore,
lords.
Why? If Raji were to be alive, would you come back to this property?
My lords, the Hindu
You
Succession
did
Act
not.
only
you did
gives
not,
rights
no,
to
no.
the... Please,
See, Dharmecha is one part. Arthecha is another part. You
Indeed.
are now enjoying the property left behind by Rajiv and contribution by Madhavi. Right?
my lords, contribution do not equate to inheritance rights.
Wait. Somebody else's Arthecha. So you are now greedy. Dharma you did not do it. You left.
My lords,
Now what do I do for Dharma?
my lords, Dharma is answered that even if husband
Now
was
what do I
away,
do?
Dharma shows, my lords, the wife has still remained unmarried.
No,
Wife did
that's
not
what-
get into
that's what-
cohabitation with the other man, just
see.
like how Rajiv did in this case, my lords.
No. See, Dharmecha is not performed by you. You failed in that. Arthecha, you failed in that. Now Madhavi has put in her money from her teaching profession and then built whatever that property is now, which is now sought to be in the court. Now Arthecha you did not. Next is Kamecha. For that also you failed. So for biological compulsions, Rajiv found another companion. What is wrong in that?
My lords, with
So
utmost
I will have to simply keep quiet, thinking that you will come back one day and die.
My lords, with utmost respect, my lords, that relationship, Dharmeja, all those things are done by a woman who was
you
having
said, you commenced your argument.
Please, my lords.
Taking clue from what the other side quoted.
Indeed.
And what the court also said. Court
Please,
knows. See, if the court knows how to make the lock, court also knows how to make the
I
key.
bowed on, my lords. Indeed,
How
my
to
lords.
make the key.
That's absolutely true, my lords. I
So,
bowed on.
you failed. You are a person who failed in all the three duties. You were never a dutiful wife.
Your lordship,
And that ruined my life.
lordship, if
That's
I may.
what Rajiv said. you are never a dutiful wife, therefore you ruined my life. So I found a new life in Madhavi.
That itself shows, my lords, 15 clause 1, bigamy. It
Not
is an
bigamy.
illicit marriage.
Who said bigamy? Bigamy will come into picture.
My
You are-
lords, please, my lords. My lords, the relationship what he
Madam,
has.
if the Rajiv was not good to you, if he was cruel, which made you to go away,
Right, my lords.
if there is some other problem that has happened,
Please, my lords.
if any other issue were to be there, you should have approached the court, obtained an order of divorce, taken mental, whatever the permanent alimony, and you could have been mentally safe, peace, and Madhavi could have also been in a good position today. Because you remained away from Rajiv without taking any course into
Your
the law.
lordships, the remedy of divorce, decree, or restitution of conjugal rights are only enabling provisions, my lords.
Who
They
said?
do not
Who
have
said?
a duty.
No.
Please,
no.
my lords.
No. Earlier to Hindu Marriage Act being enacted in
Please.
1956,
True, my lords.
there was no other method that by which we could separate.
Indeed, my lords.
Therefore-
But considering today's situation, my
No,
lords.
not today. Law. Don't say today's situation. Law now will envisage 13 section in Hindu Marriage Act gives you 2 or 3 provisions to take the divorce. Then 13B by consent. Things made easy. So slowly, after the Hindu Marriage Act 1956, the concept of marriage of Hindu marriage has shifted away from sacrament to the somewhat a quasi-contractual.
Obliged, my lords.
So somewhat quasi-contractual because we have introduced the provision called divorce.
Indeed.
Right.
If I
So
may.
means what?
Please, my
Means
lords.
what?
My lords.
There is an exit clause in the contract. What is that exit clause?
My lords, if I may
What
ask.
is that exit clause?
Exit clause from the marriage, my lords. If I may.
Divorce.
Indeed, my lords.
Divorce.
If I may answer, my lords, I'm very grateful for this question.
No, wait.
Please,
So Sukanya could have gone to the court, obtained the decree of divorce. Now, I'll give you another example.
It's not condition precedent, no, my lords.
Rajiv has left behind 50 crores of debts. Will you clear?
My lords.
Will you
that's
clear your legally wedded wife?
Respectfully denied, my lords, because
Why?
succession rights
Why?
are given to the wife,
Why?
not
Why?
the debts,
Why?
my lords.
No.
Not the debts, my lords.
No. Who said? You are liable. Provided you own the property left behind by the. All right. Now,
Obliged.
both of you are fighting.
Please.
Bank will come and file a suit for recovery of 10 lakhs. Who will pay?
The legally wedded wife, that is Sukanya, would bear if
You
the debts were
pay.
there.
You pay now.
My lords, if the
You
debts are
pay
there,
now.
the Sukanya would truly
You pay
bear it.
now. You pay now.
If I may, my lords.
Madam, very simple point.
Please,
Sukanya never wanted this relationship. You are an avaricious woman, taking advantage of untimely death of your husband, whom you have not seen for 8 years. You have come to the court denying the right for another lady and a child
Your
which has not committed any sin, and you got the suit dismissed.
Lordships, if I
You
may,
should have been,
please.
if you are so honest, you should have said, yes, so far as my right is concerned, 50%, that balance 50%.
Obliged, my lords.
That, no, your written statement denied
My lords, if I
everything.
may please gone out of my lords, void and voidable marriages. Here, my lords, this is not a marriage at all.
No,
It's
ma,
just a living
no,
relationship.
ma, that's why it is called illegitimate. Yes.
Indeed, my lords. My lords, if I may first.
Don't try to confuse the court with void, voidable, this, that and all.
I will be mindful, my
A
lords.
child born out of
Out
the
of a-
marriage cannot be termed as a bastard.
Indeed, my
Therefore,
lords.
section 16 has been introduced. To
Right.
remove the label of bastardism, section 16 has been enacted.
Please,
Therefore, illegitimate child has got a right. It is not the marriage. Even
Highly
the-
obliged, my lords.
That's all.
If I may answer your question, my
Comfortable?
lords.
Yes. Comfortable.
Your lordships,
Don't
the
worry,
bench is.
if you were to be here, you would have been more comfortable if you see these questions. Sit down.
My lords, we
Take
are,
it easy.
we
Take
are
it easy.
equally enjoying the bench's questions, my lords.
Not enjoying, madam. Please.
Please,
These are
my
all
lords, if I may.
our efforts are here only to, not to, make you feel that you don't know anything,
Please,
but
my lords.
to kindle the thinking process. Please understand.
Indeed, my lords.
See, nowadays, ready material is available. By hearting and making it is of no use. Please understand. We are dealing with the burning problems in the society. See, it is not an engineering course. It is not a science. It is not a maths where 2 plus 2 is equal to 4.
Right.
In law, 2 plus 2 is never equal to 4. It is always something more or something less.
Obliged. Indeed, indeed.
All right. So you will have to work it out in that direction.
Please.
So we have put you 3 inconvenient questions.
Correct.
First is, what made you to live 8 years and go away?
Indeed.
Second in uncomfortable question is, what? Why did you not take divorce? Third is, if there is a debt, would you pay?
My lords,
Now
to
your
answer the
co-counsel.
first issue, my lords,
Yes.
as the bench has rightly stated, under section 13, clause 1, subclause IB says, my lords, desertion is a ground for divorce. But, my lords, it does not say this ground itself automatically says it is a divorce. Because, my lords, desertion is a matrimonial wrong, but it is not a self-operating dissolution.
Where were you for all these 8 years?
Lordships,
Because if a person whereabouts are not known for 7 years,
please.
he will be presumed to be as a dead.
Civil death.
It is a civil death.
They knew each other.
If such be the case, you are no more a husband to the Rajiv, no more a wife to the Rajiv.
Indeed. Your lordships, when it comes to the recognition of the marriage,
No.
Madhavi is the only the wife, not Sukanya.
See, the
Lordships,
problem is,
please.
you are also a teacher. Madhvi also a teacher.
Indeed.
Rajiv also a teacher.
Indeed.
Each one cheated you. You cheated Rajiv. Rajiv cheated you.
If I may stand corrected, my lord, Sukanya did not cheat, my
Madhavi
lords.
cheated Sukanya, and Madhavi cheated her husband also.
Indeed, my lords.
Ah.
That we kind
So
of
all
acknowledge.
cheaters.
Not Sukanya,
not
my lords,
teachers.
in this case. My lord, Sukanya may not be considered as a cheater because till date, my lord, Sukanya is still a single, unmarried woman, married woman who is a widow. till date.
Pay debts of Rajiv. Now bank will file a suit.
Indeed, my lords, if your lordships would consider that Sukanya is a valid wife, we will very well, my lords, we will pay the debts. If her successionary rights are
No, madam,
validly
you are the wife.
mentioned-
There is no consider at all. You are the wife.
Lordships,
You
when
are
your
the
lordships
wife.
are focusing
When it-
on the Madhavi as a wife,
No.
I'm also reminded.
No.
Please.
Please. You are the legally wedded wife. There is no doubt about it.
Much obliged, my lords.
No, that is there. That we have told. We have told your first arguing counsel on this side. We have told at any rate, Madhavi cannot be equated to a wife. You are the wife. Fine.
Indeed. And the law is still, the marriage
No,
is
not
still
only that.
subsisting as well.
No. Wait.
Please.
Now, once you get the, the label of wife, Succession Act, your role is a something different role. You understand that? So, you become the widow of Rajiv. So, that's how you get the right.
Indeed, my lords.
Now, the point is, before the court of law, we have a situation, we have a widow
Indeed, my
and
lords.
an illegitimate son.
Right, my lords.
Now, widow and illegitimate son, how do they share the property by succession is the next question.
Indeed, my lords.
Right? Now, the law in the 𝐏𝐻𝐯𝐞 case, which has been approved in Revan subsequently,
Indeed, my lords.
whatever the properties self-acquired left behind by Rajiv will have to be divided between the two persons, or if there were 3, 4, whatever it is, equally.
Indeed, my lords.
Right? Now here only Sukanya and that illegitimate child is there.
Right,
So
my
the
lords.
point is, suit is to be decreed in 50% each, that is half share. That's all.
That is up to your bench, my lords, on the...
No, not up to, you should concede for that.
Please, my lords, if I may, my lords, if I may be allotted some time to please
Even
convince
if you
your
don't,
lordships.
even if you don't concede, law will do that.
Please, my lords, I bow down, my lords.
Yes,
I would
that's it.
truly appreciate if any opportunity would be given to speak and convince your judge, your lords, firstly. Wherein, my lords, I would want to draw your attention that if Sukanya, only on the ground that she was deserted for such a long time, would not be considered a wife, may also, on the other hand, let us assess, my lords, merely because there is a social recognition and a cohabitation
Don't
for
worry
such a
about all
long
that.
time.
No, we have not agreed with them. Don't strain yourself. Have a seat. Let the other lady.
Lords, I oblige, my lords. The last
Yes, yes.
argument what I want to make, my lords.
Yes, yes.
Whenever a legislature, my lords, delegates a law, it shall be interpreted accordingly. And my lords, these doctrines and principles cannot prevail the laws which are on the paper.
No, that's not the argument. Argument is any amount of social concern, etc., etc.,
May be
etc.
considered.
No, etc. will not override the law. That's the sub.
Please, my lords,
that's it.
I
You can
vote
take
on,
it.
my lords.
Yes.
With that, my lords, the validity of the Sukanya stands still, my lords, and she is the legally
She is
wedded
the wife. Yes.
Indeed, my lords. Obliged, my lords. It was an honor pleading before your lordships.
Yes, madam. ಅದು ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಮಾತ್ರ ಅದು ಇವ್ರಿಗೆ ಬರುತ್ತದೆ ಬಂದಾಗ ಇವ್ರಿಗೆ ಹೇಳಿದ್ವಿ ಎಸ್ ಮೇಡಮ್ ಲೆಜಿಟಿಮೇಸಿ ಆಫ್ ದಟ್ ಚೈಲ್ಡ್
Good evening, Your Lordships. A pleasure to be arguing before this bench today. The issue that I am addressing is, as rightly mentioned by you, about the legitimacy of Ajit. Your Lordships, you have also rightly held that Ajit will not be a legitimate child in the case at hand. I would like to substantiate the same point with a few citations as well as the law in itself. Your Lordships, the trial court has very correctly held that Ajit will not be able to gain any inheritance rights, and this is substantiated by the fact that Rajiv and Madhavi were never in a marriage in itself. The relationship that they have been in is merely a cohabitation or a live-in relationship, and this will not equate to a marriage. Your Lordships, whenever a citation has been put forth which states that the court has said that any child born out of a void or voidable marriage must gain access to the provision section 16, we draw your attention to the fact that here it has still been a marriage. It is a void, voidable or a valid marriage. The intention to marry has consistently been present in all of these. Your Lordships, however, in the case at hand, there has never been an intention to marry between Rajiv and Madhavi. In that, owing to that, Your Lordships, when Ajit is born out of this relationship, in no circumstances will he be able to claim the rights of an illegitimate or
How do you know? You are away. 8 years away. What Rajiv had the intention with Madhavi, nobody knows.
Indeed, Your Lordships, I agree
Birth
to
of
that.
a child will show what?
Indeed, if I may answer your question.
Yes.
Your Lordships, we completely agree to the fact that Sukanya had deserted her matrimonial home.
No,
However, Your
madam, very
Lordships,
simple. If I only wanted to use Madhavi for my biological compulsions, I would not have gone to the extent of having a child.
indeed, Your Lordship.
So
Your Lordship,
child means what?
he is a progeny of his parents, Your Lordships.
Therefore, Rajiv wanted to have the company of Madhavi for all time to come.
Indeed, Your Lordship, there is no question about Rajiv
So
being
intention
incorrect.
of marriage will have to be inferred by resorting to section 114 of the Evidence Act.
Your Lordship, the presumption of marriage must also be looked into, keeping in mind the
Brother has
fact.
already told about what is presumption.
Indeed, I very well
Don't
note
worry
that.
about presumption. See, there is no shall presume. There are 3 types of presumptions, no? One is shall presume, which is a statutory presumption. Another is may presume, which is a unfactual aspect.
Indeed.
I have told you, your friend, may is equal to
Discretion.
not.
Yes.
So it is 50% probability. So if the court doesn't presume, in a may presume, then entire burden is on the person who wants to take that particular stand. The third one is what?
I'm sorry, Your Lordship, I'm unaware. of
Conclusive proof.
that. Indeed.
See, you should know which year you are in.
I've just entered my 4th year, Your Lordship.
Evidence Act is over, no?
Yes.
Then,
So, I'm currently studying.
yes, section 3 is over at least.
Indeed.
Ah.
I completely agree, Your Lordship.
Therefore,
I plead
what is
ignorance to this
conclusive
fact.
proof?
Your Lordship,
What is conclusive proof in this case?
Your Lordships, we agree to the fact
No,
that
please tell me, what is the conclusive proof in
the
this
marriage
case?
certificate, Your Lordship, the registered marriage certificate
No,
in question.
no, ma. Conclusive proof is the Rajiv and Madhavi getting a child.
Your Lordships, if that is the case, then
That's all.
Your Lordship, if that is the case, then every relationship can come out,
No,
claim
ma,
to be
please
cohabitation,
understand.
and claim
Please
legitimacy
understand.
rights.
No, ma, please understand. See, you must understand what the court is trying to tell you. Court is trying to tell you that here is a situation where you wanted to say that was there any intention between Rajiv and Madhavi to marry each other. What is the conclusive proof that has reached here?
Your Lordship, we cannot purely rely on what would have happened if Rajiv had continued to live. That is not an
No.
consideration that can be made.
See, if Rajiv were to, that's what, while answering your friend also we said, And your this side friend also, to the madam especially, we said what? We said what? How do you know all these things? You are away.
Your Lordship,
8 years away. You don't know what was happening inside the
Indeed.
four corners, right?
Indeed.
What is the degree of proof in a matrimonial matter?
Your Lordships, as mentioned by
No,
the
wait,
Honorable
wait.
Bench as
No,
well,
wait,
we are...
no, don't jump. What is the degree of proof? You have any idea?
In this case, Your Lordship, yes, we are...
Degree of proof required to be placed before the court.
Indeed. I'm sorry, I plead ignorance to that fact, Your Lordship.
Now, degree means what? Evidence Act is common for civil cases, criminal cases,
Indeed.
all cases. We
Indeed.
don't have a separate provision for criminal cases. In case of criminal matters, court will look forward for the proof beyond reasonable doubt. Have you heard this?
Indeed, I have, yes.
So what is beyond reasonable doubt?
It must be wholly proved, Your Lordship. There has been no iota
How
of
do you
doubt.
prove wholly?
So we're following the same principle here as well, Your Lordship.
No. That's
Beyond
what.
doubt, we have proved that she is
No.
married to Rajiv.
That's why you are in a wrong. Wrong proposition of law. You should not. See, beyond reasonable doubt. Have you heard of what is the person sitting on the armchair theory?
I have not, Your Lordship.
See, now this problem, let us say, we give it to that cameraman. 100 such people we call, one canteen fellow, one cameraman, right, one sweeper. We'll make them understand, make them to sit in a common chair like this, armchair. Who doesn't know the law? They know the facts. So we will put it across. That, look here is a lady who left her husband, did not look for 8 years, and after his death, she came here for the property rights. And here is the person who gave all benefits to her husband, that is the Sukanya's husband, had the pleasure of company, beget a child. Madhavi also puts in her money, they develop, they flourish, and she is claiming. So this proposition, if it is put to this 100 such people who sit in the armchair, and what do they think? Wait, no, not you, they.
Sure.
What do
if
they
I may
think?
answer.
Is the opinion that is to be looked into.
Indeed, Your Lordship. If I may
Wait.
answer your...
Wait, don't answer. You
Sure.
don't know, therefore don't answer. Right, wait now. If 90 people were to fall in one place, then that is called proof beyond reasonable doubt.
Your Lordship, but that is what differentiates the
Wait,
Honorable
madam.
Bench from a common man, that we expect that the law
Will
is
you-
able
will you
to
wait?
grasp...
Will you wait?
Sure.
Will you wait or you want to have your
No,
own?
please, Your Lordships. Please continue.
If it is 51 to 49, this is called preponderance of possibilities.
Indeed.
Right?
Indeed.
This scale will vary. Moment it becomes 52. Here it goes 48, 53, 47.
Indeed, Your
Likewise, 91, 0. Preponderance of possibilities can be 51 to 49 onwards, anything. In case of matrimonial disputes, it is something more than preponderance of possibilities and less than proof beyond reasonable doubt. This is told in Dastane versus Dastane by the Supreme Court.
Indeed.
Go through that judgment. Now, these are all the works for the proof.
Indeed.
Now, you are sitting away 8 years from this house, this relationship, you don't know what is transpired in the day-to-day activities.
Indeed.
All that surfaced because Rajiv is no more. If Rajiv were to continue, if he were to be alive, this case would not have been there before us.
If I may answer your question.
Case will be still there.
Sir, if I may answer the question you have
Yes.
just posed, the facts very clearly state that Sukanya
Whether the
had
case
only-
would be there or not, simple yes or no.
If he had sustained no, sir, the case could have still been there when the
No, ma,
crux of the
please.
problem is that Sukanya was not aware
One
of the
simple
fact.
one simple question. we
Yes,
are
sir, the
putting
case
on.
would have still sustained. It would have
How?
still sustained on the basis.
How?
I will explain this to you, if you allow me to explain it.
Yes, we are allowing you.
Yes.
How?
If I may speak.
Oh, who is
Right.
filing the suit?
Your Lordships, the basis on which we are arguing this is that Sukanya
No, ma,
was
please.
not aware of the fact that
No, ma.
Rajiv has
One
got into
second.
another
If
relationship.
Rajiv were to be alive, can there be a suit for partition?
Your Lordship, there would be no suit. Sukanya would still be the rightful heir because he has
No,
not
she is
gotten
there.
married to
She is
Madhavi.
there. Heirship will come when? Heirship will come when?
Your Lordships, up
Heirship
until,
will come when, Amma?
Your Lordships, we cannot argue on the basis of what has not happened in the
No,
future.
no, that's why I am
So,
asking you, if the Rajiv were to be alive, whether this suit would be filed.
Your Lordship, that is not something that we can think about in this instance because it hasn't happened yet. To question that
Simply
itself
answer,
would
ma.
be purely hypothetical, Your Lordship. It wouldn't hold any bearing in
Hypothetically
law.
also, you just simply answer, no? Why don't
Lordships,
you answer?
even if a suit even if Rajiv was alive and we undertook a suit,
please,
Sukanya
Nodi.
would still come out on.
Please see the note that your friend has given.
Your Lordship, it was an interstate death.
Rajiv is still alive, no?
Your Lordships, indeed, if he was still alive, the property would still devolve only to Sukanya, Your Lordship. It would not devolve to his. Your Lordship, there is no marriage subsisting. She will not fall under his widow, and he will not fall under his legitimate child. So, on what basis will the appellants claim?
If I were to be the lawyer, I would have filed a suit for partition through illegitimate son. That's all. That too after the death of Rajiv, not before the death.
Indeed, Your Lordship, but the facts in the case are as such, which compel me to argue
So
in a manner.
no, Madhavi cannot maintain a suit. That is your argument. You should have stated from there. That's
Indeed.
what we are asking for.
We-
Madhavi herself does not have any right to file a suit. Therefore, her suit is bad in law. However, if Madhavi is claiming the right as the natural guardian of that illegitimate son, then suit to that extent is maintainable, is entitled for 50%. That is what we are looking from your arguments.
Indeed,
Hope
Your
we have
Lordship.
summed it up. Anything else for the rebuttal? You can keep it. Yes, anything, sir?
Your Lordship, if I may be allowed to argue for a while.
Yes, what do you want to argue? You want to
Lordship, we
file a
want to
suit,
argue
still if the Rajiv is available, alive, then still the suit is
No,
maintainable.
Your Lordships, we are not considering that
Yes.
hypothetical at all because it hasn't
Not
happened
hypothetical, ma, please understand. That's what we are asking you. We have asked your counsel also that there is a situation where the property is left behind by Rajiv. Therefore, you are trying to lay a claim. You are not contributed a single paisa to the estate of Rajiv. Your only requirement that you have is the law protects you because you are the legally wedded wife. Law protects you, you are a legally wedded wife. Therefore, you are taking advantage of your heirship and then claiming. Nothing more. Otherwise, you are not entitled for anything.
Your Lordship, if I may answer.
That's what the people would say if the out of 100.
Your Lordship, once again, I would like to point out that
Yes, yes.
the honorable bench
No,
is
no.
not
No,
cannot
no.
be compared to the common man, Your Lordships. We trust.
No, this is a civil suit, a preponderance of possibilities.
Indeed, Your Lordships, we have
No,
also.
no, this is a civil suit. Common man theory will come into picture here.
Indeed, Your Lordship.
Civil suits are proof that is required is preponderance of possibilities.
Indeed.
At the same time, it cannot ignore any statutory law.
Indeed.
So you are 50% entitled. That suit, nobody can take it away. By what? Just by marrying a person. Just by marrying a person, you got 50% of the property.
Indeed, Your Lordship, the preponderance of probability principle that you are mentioning, we have also argued on the same ground that in this case, when looking at the evidence placed by both the parties, by the respondent, we have placed a registered document, Your Lordship, and the appellants have merely provided documents on the basis of
No,
convenience.
you are legally wedded wife for the.
Indeed,
for
Your
which
Lordship,
no,
indeed.
not necessary. No proof is required. There is an admission.
Your Lordships,
Admission
we
means
have-
what? Which section will govern? Evidence Act, which section? You are right. You come again. Admission. Admitted fact need not be proved. Section 50. You can also assist on the question of law. There is no. 56. See, that's the point, no? See, if I were to be the counsel for Sukanya, I would have filed my written statement. 50% I am entitled, decree the suit, that's all. My written statement is one line.
Your Lordship, but we are arguing that Ajit...
Why should you argue when there is an admission? Look at the plaint, no? Look at the plaint, no? Plaint, they themselves say that this defendant Sukanya was the legally wedded wife. However, she is not entitled for any share because she deserted, and I being the living in relationship, I should be considered as wife. So when they are unable to explain and then propound before the court that they are the wife, then automatically by natural course you are the wife.
Indeed, Your Lordship,
That's
that is not disputed at all. As the Honorable Bench has mentioned, Sukanya's status as a wife is not disputed. What we are disputing...
They have disputed.
They have disputed. Indeed.
They have
the
disputed.
Honorable Coach has... the Honorable Bench has... we are in agreement about the fact that Sukanya is in fact the lawfully wedded wife. That is not a...
No ma, see, issue is they failed on that issue. Now what will happen if they fail on that issue?
Your Lordship, it is not possible for us to fail on this issue because
no
we are
ma,
providing...
please understand, you are not expected to prove the negative. See, that concept it should go into your head.
Your Lordship.
See, their plaint itself says that Sukanya was the earlier wife. But what they are trying to say? They are trying to say that she deserted for 8 years. Therefore, Rajiv was compelled to have this relationship.
Your Lordship, compelled is a very strong word to use. He wasn't compelled.
It is compelled.
To get into this
It is compelled because you
Your
did
Lordship,
not.
in that instance,
No, he was compelled. He was compelled because you did not do any dharma, you did not do any artha, you did not do any kama.
Same could have, Your Lordship, Rajiv made no efforts to reconcile the differences between the marriage.
You should have.
Your Lordship, it is a...
You should have.
It's the case of...
you should have, ma.
Indeed, Your Lordships, I very well admit that.
You should have.
Indeed.
Expecting the other man and not that particular person not performing is not an excuse for not making efforts from your side.
Indeed, Your Lordship.
How many times you visited? How many times you picked up quarrel? You wanted to say about bigamy. Did you file any criminal case? What prevented you?
Indeed, Your Lordship.
What prevented you? You knew very well that what I could not give it to Rajiv, Madhavi has given it.
Your Lordship, if I may mention a fact, Sukanya was not aware of the fact that Rajiv has entered into this cohabitation with Madhavi in the first place. She has only
Look at your written statement. Look at your written statement and then say.
It is a fact, Your Lordship, in the Moot proposition.
No, look at written statement. What has been stated in the statement of facts?
Okay.
I am holding your papers here.
Indeed,
Yes.
I was getting myself.
See, that has been provided by the, facts. It has been provided there. You just see. See the one line.
Indeed.
You want me to point out, or you will yourself point out?
Sir, I am not aware if you are looking into the memorial or the proposition. If you could clarify that.
Proposition, facts has been stated there, no?
Indeed, I will.
And you have reiterated the same thing in your paper.
Your Lordship, sure. If I will also point to the facts
Yes,
and clarify
yes,
this doubt.
yes.
If you may please turn to paragraph 15 of
Read,
the Moot
ma,
proposition.
read.
It says, in May 2024, Sukanya, upon coming to know of Rajiv's demise through village sources, Your Lordship, she did not wait for him to pass away and then pounce on the opportunity of gaining inheritance in his property, Your Lordship.
Moment you came to know from the villagers, what efforts you made is the next question.
Your Lordship, it is not something she sought out. This information is something that came to her over her going after it only.
What did you do is the question.
Your Lordships,
what a normal person will do. Normal, prudent person conduct in such circumstances, what is the expected of? She will go to the workplace where Rajiv was there, pick up a quarrel, call TV9, make it an issue, half a day, breaking news.
Your Lordship, all we are trying to prove.
ಹೆಂಡತಿಗೆ ಮೋಸ ಮಾಡಿದ ಟೀಚರ್, ಇನ್ನೊಬ್ಬಳ ಟೀಚರ್ನ ಹಿಂದೆ ಬಿದ್ದ ದೊಡ್ಡ ಟೀಚರ್ ಇರ್ತಿತ್ತ ಇಲ್ವೋ? ನೀವೇನ್ ಮಾಡಿದ್ರಿ?
Sir,
ನಥಿಂಗ್.
Sir, the same can be said about Rajiv as well.
No, why he will?
Sir,
He is the beneficiary.
He went above and beyond his way to ensure that
No, he is
was unfaithful in
beneficiary.
his marriage.
He is well off, cool off, because he never wanted Sukanya. So Sukanya left by herself. So I had the benefit of Madhavi. Have a child. What more? Mine is a Sukha Samsara. Right? See, law expects you, certain principles in the jurisprudence should come to you. what the law would say. Why the law of limitation? Law always protects the vigilant, not the negligent.
Indeed.
So law expects 8 years, nothing has happened. Brother has pointed out, if you have not seen that where the Rajiv is, it may presume to a civil death. Jivan Chaitra, Rajkumar going to Kashi, and then found by Umesh. Right?
Indeed, Your Lordship.
See, law expects you to have that relationship continued or not.
Indeed, Your Lordship, definitely.
You cannot keep quiet for all time to come.
You know,
And when that person is not there, all of a sudden your rights get. That's where the court is looking at this. That's why the other side wanted especially madam, equity, equity, equity. What will happen? She did that. But our courts are law courts.
indeed.
See, while arguing, we also pick up the good points. Our endeavor is to see that, you get prepared. This is a moot court.
Indeed,
You are not going to lose anything here.
Indeed.
At the most, one runnership or winnership, that's all. Little bigger shield, little smaller shield, that's all.
Indeed, Your
Okay? But when it comes to the question of the real life, when you are the lawyers, if you go with the small preparations, no, it's not going to happen.
Lordship. Indeed,
The
Your
whole idea of moot court is to see that you get prepared. You go to the minor details. Attack the problem from the first principles of law. What is the statute which governs? So therefore the framers themselves would have given, these are the statutes that you may be looking for. So this is a situation where we have made it in such a way that, what is happening in the society is brought into in the form of the
Indeed.
moot proposition, so that certain churning can take place, new ideas can come, which may ultimately work out in favor of a person who is really suffered. In the whole process, the one person who really suffered is Rajiv.
I
Therefore, he
beg to
lost.
differ, Your Lordship.
He lost his life. And you see, this is not the isolated case of Rajiv. This is happening day in and day out. I had a situation in Kalburgi where our court peon had the 4 relationships, not one. And his emoluments were only 2.5 lakhs. Then when we were in a position to work it out for him, intersave all these people, one fellow came and he says, "Sir, my mother is 5th and it is a registered marriage."
So then,
What will happen now? See, look at all these things. This is not happening for the first time. This is happening in the society. Such Madhavis are found. Such illegitimate children like 𝐏𝐻𝐶 are still suffering. People like Revan Siddhappa trying to lay claimants on the ancestral property also. Brother pointed out that, you will get the share.
indeed.
Major share because there are ancestral properties of Rajiv also.
Indeed, Your Lordship.
And self-acquired.
Indeed.
So ancestral properties of Rajiv, that illegitimate child cannot claim. So only in question of self-acquired.
Indeed.
All right.
Your Lordship,
So-
if I may conclude my
Yes, conclude.
presentation. Your Lordship, I would just like to make one
What
final...
more to be concluded?
I have a final point to make, Your Lordships, and I will take your leave.
Yes, madam.
Your Lordship, the
Yes,
final
madam.
point that I would like to make
Yes,
is that
madam. Yes, madam.
desertion would not be a grant for not giving succession, which your courts have rightfully admitted to as well.
Yes.
So, Your Lordships, if you may allow...
We made your job simple by asking few questions to the other
No,
side.
we had...
Yes.
Indeed, Your Lordship. If I may move to the prayer. Wherefore, in the light of the issues raised, arguments advanced and authorities cited, the counsel for the respondent humbly prays that this court may today declare...
Both of you did not address the issue with regard to the maintainability. 96. That's also an issue, no?
It's not a issue in question, Your Lordship. It is a self...
Your friend argued the open thing was that
Indeed.
about the jurisdiction and the 96 appeal.
Indeed, Your Lordship.
Yes. It is maintainable. Yes.
Indeed. Declare and affirm that the marriage between Rajiv and 𝐶𝐐 was solemnized and registered and has continued to subsist up until this date, and consequently declare 𝐶𝐐 as the lawfully wedded wife of Rajiv, Your Lordships. Secondly, we would appreciate the court declaring the relationship of Rajiv and Madhavi as invalid Apart from this, also declare Ajit to be an illegitimate child and uphold the Tehsildar's mutation order showing that the rightful owner of the property should be Sukanya.
Yes, madam. Thank you.
Much obliged, Your Lordship.
Doing all these things, should have told you only one sentence.
Dismiss the. I was coming up to that, Your Lordship. I was just. That was my final prayer, Your Lordship. I was.
Your prayer is more than.
No. We request the court to uphold the trial court's order, Your Lordship. We're requesting
Madam,
that it be
madam, please
upheld.
understand. Drafting, you must go to section 6, order 6. Order 6 of the CPC, adhere to that. If you are a defendant, what you have to seek is, unless you are seeking a counterclaim, you can only make a prayer for dismissal of the suit with cause, and sometimes in the exemplary cast under section 35A. That's all. When it comes to the question of plaintiff, he has to make a distinct, separate prayers for each of the reliefs and necessary consequential reliefs.
Indeed.
Right, that's all. So the written statement or the appeal respondents, whatever that you make it, it need not be so long is what
Indeed.
the brother said.
Indeed.
You could simply say dismiss the appeal.
We request that it be upheld, Your Honor.
Yes. No, upheld is, if you dismiss the appeal, automatically upheld.
Understood, Your Honor. It was an honor arguing before
Yes,
the bench.
yes. Both the teams have done well. Any rebuttal? Yes, please come. Please come.
Your Lordship,
Yes, ma'am.
I would like to introduce you to a term called hot bench, Your Lordship.
Oh, very good.
The heat combined, the Puttur heat combined with the hot bench made my brain stop working for a minute and I had to
Don't
cool down outside, Your Lordship.
Don't worry.
Yes,
you
Your
are all
Lordship.
right now?
Yes, Your Lordship.
Comfortable. Very good.
Yes, thanks to AC, Your Lordship.
Yes. And thanks to us also.
Yes, Your Lordship. Very much, Your Lordship. I shall complete my prayer first and then move on to the rebuttals,
Yes,
Your Lordship.
Yes.
Wherefore, in the lights of issues raised, arguments advanced, authorities cited, it is most humbly and respectfully requested that the Honorable High Court of Karnataka, that it may be pleased to adjudge and declare 1. Allow the present regular first appeal under section 96 of the Code of Civil Procedure 1908 and set aside the judgment and decree dated 2012-2025 passed by the learned civil judge and JMFC Sullia in original suit number 124/2024 as being contrary to law, evidence and settled principles of justice. Second, declare that the relationship between appellant number 1 and deceased Rajiv constitutes a valid marital union by presumption and that appellant number 2 is their legitimate child entitled to succeed to his estate in accordance with law. Third, declare the appellants are entitled to joint title and possession of the suit property and consequently set aside the mutation order dated 15/7/2024 with directions for correction and revenue records in their favor. Fourth, any other relief which the Honorable Court deems fit in justice, equity and good conscience, although the court is court of law. Your Lordship, I shall scrutinize or ask few questions to the respondents, Your Lordship. Firstly, their prayer asked not for dismissal of the case, but for asking to declare the child illegitimate. What kind of intention they harbor, we cannot make out. Your Lordship, firstly, they said that Rajiv is not alive and that's why Madhavi is not entitled for anything. Had he been alive, he would have written a will, but he died intestate. And child is legitimate regardless of the marriage between Madhavi, if we consider it a marriage, regardless of the relationship between Madhavi and Rajiv, whether it was legitimate, illegitimate, married, unmarried, the child will be given property because it is his legal right according to section 16 of the Hindu Marriage Act, Your Lordship. Secondly, I want to say that the facts I want to highlight some that Sukanya approached the councils after she got to know about the death, asking, facts clearly say that, asking if her marriage is still legally valid, still legally subsisting. She was in her own confusion that whether or not she is the legally wedded wife of the husband, which if we consider the husband right now. So if she is still in question of she is wife or not, how can she claim that she was wife for so long and then now she is the widow of Rajiv, Your Lordship? finally, the questions which I want to ask to the respondents, counsel for respondents is, by seeking to evict the appellants, are they not violating right to life and liberty and dignity under Article 21, particularly that of the minor child? We have to really focus on the minor child because he will be kicked out now that his biological father is not living with him. Second is, what about the 2,65,000 Madhavi invested in the land? And should Sukanya be allowed to profit from these improvements without compensation? We seek for that as well. Thirdly, if son Ajit is illegitimate, legitimate according under section 16, why should he not be entitled to an equal share in the ancestral property alongside the respondent? These are the questions which we seek the answers from the respondent, Your Lordship. Much obliged. Is there anything which the Lordship wants to ask?
You yourself are in confusion in the last question that you put it across.
Yes,
Revan Siddhappa.
Yes, Your Lordship. Yes, Your Lordship.
Revan Siddhappa will cover that. So don't ask that question to them. The rest, the three, let them answer.
Yes, Your Lordship. Much obliged, Your Lordship.
Yes. She wants to say something more. Yes. Okay.
Your Lordships, firstly, counsel is relieved that my learned counsel is back with all the confidence. However, without offending your patience and research, the counsel would want to rebut every point, my lords, to answer the relationship of Madhavi, as the learned bench has itself pointed out that Madhavi cannot be wife of one person and widow of the another, my lords. That answers the question, my lords, that Madhavi itself is not cannot be considered, or is she in the ambit of widow or a wife as per the laws prevailing in the land. Secondly, my lords.
Who performed the funerals of Rajiv?
My lords?
Who performed the funeral of Rajiv?
My lords, the
Have you?
facts, please. My lords, facts does say that Sukanya was not present. However, my lords, the unfortunate part is, my lords, Sukanya never knew what was happening in the life of Rajiv and Madhavi, because she was always kept in dark, my lords. She was completely deserted, and the man, that is Rajiv and Madhavi, always had a life of domestic relationship, which is termed by the councils, which is again not considered as a marriage at the first instance, my lords. Considering, my lords, Sukanya was a person who is a poor lady, my lords, who is away even from the marital relationship of a husband, where she is again unmarried till date, then, my lords, the bench shall have to look into the successionary rights as well as the validity of the marriage and grant
don't claim yourself as a godly woman. You are not.
Please, ma'am. However, my lords, Sukanya, my lords, did not marry how Rajiv did. That too, a woman who was already in another relationship.
No, please. You should have inquired. We have sufficiently put your co-counsel the question.
Please.
This is only rebuttal. When you came to know from the villagers, what was your action?
Lordship, firstly, my lord, Sukanya.
What was your action?
Heartfelt condolences, my lords.
Total inaction, because for you it was a closed chapter, but for the property.
Lordship, because Hindu Succession
No, ma,
Act, please.
but for you, but for the property, relationship between you and Rajiv was a closed chapter in your life. Because after coming to know about the relationship with Madhavi from the villagers, you kept quiet. Means what? Doctrine of acquiescence and waiver. Right.
Respectfully
now,
denied, your lordships.
No, wait.
Please.
So it will not go in that fashion.
Please.
Doctrine of acquiescence and waiver is a principle which is having an exception to what is called, there cannot be any estoppel against the statute.
Indeed, my lords.
So therefore, law is trying to give you some relief.
Indeed.
Take it happily and be thankful because you did not apply for divorce.
Indeed, my lords. That favors the Sukanya, my lords. And also, my lords, pertaining at the outset of the competition, my lords.
The whole point is, from the moot one can understand is, one who respects the law,
Please,
law will come to their protection.
Indeed.
One who does not respect the law,
Indeed, my lords.
they are in trouble, howsoever equity be in their favor. That is what the Madhavi is now put to.
Indeed, my lords. With that, my lords, the council considers that the validity of the marriage of Sukanya is being considered, and considering that
How
there
many
is a
times
law.
we have to say that? Yes, you please take seat.
Please, my lords, and also, my lords, at the outset of the competition, this opportunity I might not have anytime soon. So I'm very pleased to appear before this distinguished bench and also agree with the hands of equity, justice, and good conscience. A part of the possession
No,
of the
you are
property
all-
may
you
be
are
given
all-
to the Ajit.
You are all tomorrow the torch bearers of
Indeed, my lords.
the whatever the benefits that one should have from our good old and ever emerging versatile constitution. Point
Indeed,
number
my
one.
lords.
Point number two, look for suitable amendments which are required in the society to meet such contingencies. Strengthen the law, whatever there is in the already in the statute books. These type of relationships were totally unknown when we had the constitution drafted.
Very well, my lords.
Now the new nuances, new relationships are coming up. Living in relationships are now almost an accepted practice in the society. Partners know very well where do they stand. Thereafterwards, there are inter-se disputes between the living in relationship partners. Day in and day out we see misuse of the mobile telephones, misuse of the credit cards, making stealing the passwords and making huge debts and put it onto the partner. All these things we are coming up. We are
Indeed,
now
lords.
facing in the society. So the
Indeed,
criminal
lords.
action, civil action, protection, living in relationship protection act, whether domestic violence act in its sweep can take into, because the one word we are always looking for is the partner. In the domestic relationship, what we are talking of, what is the domestic violence when it comes to. So in that sweep it will come. So therefore there are certain other issues where we are required to. You are the youngsters, you are the torchbearers of this nation. Tomorrow to the principles enshrined in the constitution is to be worked out properly. These type of examples which they have, brother was pointing out that there could have been something more else also, some more facts could have been cleared, then there would not be scope for this churning, no? So churning has taken place. So all types of questions will also come.
Indeed.
So those questions from the bench is only to make that churning more profitable, so that one
Obliged.
can have at the end the butter, the cream out of it.
Indeed.
So that cream is now today what we have understood is, what we have summed it up, stating that one who ultimate from the day one, what is the principle is, one who respects the law will respect them. Dharmo rakshati rakshitaha.
Grateful, my lords.
Nyayalayadalli, that is the only slogan where you respect the law, I come to your protection. You violate me, you are in the lurch. That's the simple point. You respect me, I'll come to your protection. So any court of law, Indian courts especially, had dealt with all such challenges in a proper manner with the available the provisions of law while interpreting. We don't mind interpreting in further, but
Please, Manoj.
interpretation cannot be a subjective interpretation, it should be objective interpretation. Subjective interpretations are not meant to be serving the ends of justice. It is one's view. Moral values, howsoever strong, cannot override the legal principles of this country.
Indeed.
All our moral principles, whatever that we have, it should be there in our house within the four corners. When we step out of the house, the only value that would govern all of us would be the constitutional principles and nothing else. We are all bound by the Constitution. And what does the Constitution would say? Constitution is the one which is the only epic for the entire Indian citizens.
Indeed.
No other.
Indeed.
We may have belief in several other epics. We may have belief in several other sacred texts. I may believe in something else, somebody else may believe in something else. That's a different issue. But when we step out of our house, the one epic, one sacred grantha if you have, it is Constitution. So we cannot go away from constitutional principles.
Indeed.
So constitutional principles, within that they are trying to bring in Article 21. Yes, Article 21 is there. Article 21 is there for you. Article 21 was there for Rajiv also, for Madhavi also, and Ajit Child also. See, the Constitution, Article 21 cannot be in that fashion. That is only for me.
Indeed.
Many times it is being argued, accused is getting the Article 21. What about the person who lost his life? For his family, whether Article 21 is there or not?
It is, it is.
Then are you only looking for one person? No. So in our country, we forget the agony for the people who have suffered. Agony for the families which have been suffered for no fault. For example, in a murder, what did this young wife and children do? NDPS,
Indeed.
you want to give all benefit to the accused. What about the persons who have taken that drugs and their families have been ruined?
Indeed.
So there are certain other things which we have to look into, ponder over. The whole purpose is to balance, create a harmonious balance between the Article 21 rights for all concerned in a list.
Indeed, my lords.
In that process, you should have been magnanimous enough in filing the written statement stating that, sir, at any rate, Madhavi will not get anything, but Ajit, I am prepared to give 50% straight away in the self-acquired properties of Rajiv. And for me, if the court so thinks, put it across in the execution and claim for my contribution for the betterment of the property.
Highly obliged,
If that were to be the situation, then court would have granted the contribution made by Madhavi for the improvement of the property which you are the beneficiary now. It could have been in the form of money.
Indeed.
It could have been in the form of 60-40. Let 60 take the Ajit in the self-acquired property. Anyway, ancestral property I am enjoying. 40% in the self-acquired property. Then we would have said, yes, Sukanya is a godly lady. Not otherwise.
Grateful, my lords.
who surfaced only after the death of Rajiv and then did not even think of making the last rites of Rajiv. Sorry. Yes.
Grateful, my lords. It was such a privilege to appear before this distinguished bench. By this, my lords, I rest my case. I'm grateful,
Yes.
my lords.
Rebuttal against rebuttal. Conclusion. Yes, yes. Yes. Yes, yes, there is thunders also. We heard it. No, we have not. No, even otherwise also, we dismiss that plea with cause. Yes. Not exemplary. Exemplary, you should know the meaning in 35A. Does any written statement be filed only for conceding to the claim? Is filed only conceding the claim. Does any written statement be filed only for conceding the claim? They said, she said about exemplary cause, no? Whether any written statement to be filed only conceding the claim is the question. Didn't get it? Didn't get it? No, ma. When 35A will come into picture.
Imposition of exemplary.
Madam, please understand, written statements are filed denying the plaint averments. Okay? Wait. A fair litigant, wait. See, you should understand 35A, no? A fair litigant may concede few facts. Otherwise, what the written statement would say? I deny this, I deny this, I deny this, I deny this. Put to factual proof, strict proof, all these things. Now, exemplary caste is imposed for the conduct of the party. In knowing fully well a factual fact, knowing fully well that a fact is true or false, try to emphasize on that and waste the time of the court and put the opposite party into a long drawn, unwanted trial. No, you have lost the suit. Don't ask for exemplary. No, no, no. You are entitled as a right. Don't worry. Yes. Anyway, we are not passing the judgment, no, we are only telling you what it is. So that will be, even if you were to get the judgment, you will get in that forum.
Yes, we will conclude.
Yes, conclude.
See, before, just His Lordship has pointed out. One of Dastane versus Dastane 75. Please read. They must know that. Yes, we will. So, heard and reserved.
And don't, after reading Dastane and Dastane, don't decide that I will not marry.
ವಾಯ್ಸ್ ಅಲ್ಲಿ ತನಕ ಕೇಳ್ತದಾ ನೋಡು
Hello, hello, mic testing, hello. on guests to kindly take their seats. Please ensure your mobile phones are kept on silent mode. The valedictory ceremony will commence shortly. Thank you.
ಸ್ಟಾರ್ಟ್ ಮಾಡೋದಾ?
A very good evening to the august gathering present here. It is my profound privilege to welcome you all to the valedictory ceremony of 3rd All India Level Moot Court Competition hosted by Vivekananda Law College, Puttur. May I now request Dr. Akshata AP, Principal and Faculty Coordinators of Moot Society, Srimati Subhashini J. and Srimati Sangeeta SM of Vivekananda Law College, Puttur, to kindly escort the dignitaries onto the dais by offering floral tribute to the Bharat Mata. We are deeply honored to the presence of High Court judges as distinguished guests for this program. Honorable Mr. Justice E.S. Indresh, Judge, High Court of Karnataka, will be delivering valedictory address. Also, we have two chief guests with us, Honorable Mr. Justice V. Srishananda, Judge, High Court of Karnataka, and Honorable Mr. Justice Tyagaraja Narayan Inavali, Judge, High Court of Karnataka. And also we have with us today the President of today's program, Shri Srinivas Murthy Konda, Senior Advocate, Andhra Pradesh High Court, and also National President of Akhila Bharatiya Adhivakta Parishad. And also we have with us Shri J. Jagannath Rai, President, Bar Association, Puttur. And also we have with us Shri S. Rajashekar Hiliyar, Advocate, High Court of Karnataka. The guests are accompanied by Shri Vijayanarayana KM, Correspondent, Vivekananda Law College, Puttur, and Shri Manohar KV, Advocate and President of 3rd All India Level Moot Court Competition, and Dr. B.K. Ravindra, Director of Legal Studies, Vivekananda Law College, Puttur, followed by Moot Society Office Bearers, Mr. Dilip B.S. and Mr. Devi Prasad. To commence this auspicious occasion, let us seek the blessings of Almighty. May I now request Pavana of 1st BLLB for the prayer. I request everyone to kindly rise for the invocation.
Gajamukane Siddhidayakane Vandip Sharanu Gajamukane Siddhidayakane Vandip Sharanu Gajamukane Siddhidayakane Vandip Sharanu Siddhidayakaninna Hoddi mere venu nanu Abdishayana mahime Baddadali pevam Siddhidayakaninna Hoddi mere venu nanu Abdishayana mahime Baddadali pevam ಶುದ್ಧಮತಿಯನು ಕೊಟ್ಟು ಉದ್ಧರಿಸಬೇಕೆನ್ನ ಮಧ್ವವಲ್ಲಭ ವೇಣು ಕೃಷ್ಣಗತಿ ಪ್ರಿಯ ಶುದ್ಧಮತಿಯನು ಕೊಟ್ಟು ಉದ್ಧರಿಸಬೇಕೆನ್ನ ಮಧ್ವವಲ್ಲಭ ವೇಣು ಕೃಷ್ಣಗತಿ ಪ್ರಿಯ ಗಜಮುಖನೆ ಸಿದ್ಧಿದಾಯಕನೆ ವಂದಿಪೆ ಶರಣು ಗಜಮುಖನೆ ಸಿದ್ಧಿದಾಯಕನೆ ವಂದಿಪೆ ಶರಣು.
To formally welcome the gathering, I respectfully invite Dr. Akshata AP, Principal, Vivekananda Law College, to deliver the welcome address.
Good evening to all the esteemed dignitaries, respected faculty members, dear students, participants, members of the bar, members of the present media, and distinguished guests gathered here today. Our institution proudly bears the name of the great philosopher and visionary Swami Vivekananda, drawing inspiration from his ideals of discipline, character, knowledge, and service to society. Guided by his vision, the college constantly strives to impart quality legal education while nurturing integrity, professionalism, and social responsibility among students. It gives me immense pleasure and privilege to extend a warm welcome to all of you to the valedictory ceremony of the 3rd All India Moot Court 2026. At the outset, it's a great pleasure to warmly welcome Honorable Mr. Justice E.S. Indiresh, Judge, High Court of Karnataka, who has graciously consented to deliver the valedictory address for this august gathering. Your Lordship's distinguished presence is a source of great inspiration to all the aspiring advocates assembled here today. A heartfelt welcome to you, sir. I extend my respectful and cordial welcome to Honorable Mr. Justice V. Srishananda, Judge, High Court of Karnataka. Your Lordship's presence adds immense dignity and honor to this occasion. And we are truly privileged to have you, Lordship, with us today. A warm welcome to you, sir. I also extend a respectful welcome to Honorable Mr. Justice Tyagaraja Narayana Inavali, Judge, High Court of Karnataka, Kalaburagi Bench. Your Lordship's gracious presence and encouragement to building legal professionals greatly enrich this academic endeavor. A wholehearted welcome to you, sir. It's my proud privilege to extend a warm welcome to Sri Srinivasa Murthy Konda, President of today's program and Senior Advocate, Andhra Pradesh, and National President of Akhila Bharatiya Adhivakta Parishad. A cordial welcome to you, sir. I take immense pleasure in welcoming Sri G. Jagannath Rai, President, Bar Association, Puttur. Sir, your presence adds great value to this occasion. A warm welcome to you, sir. I extend my hearty welcome to Sri S. Rajashekar Hiliyar, Advocate, High Court of Karnataka, and Honorable Member of All India Stock Witness Reforms Expert Committee, Supreme Court of India. Welcome to you, sir. I also warmly welcome Sri Vijayanarayana KM, Correspondent of our College Governing Council. Sir, we are grateful for your continued guidance and support. A heartily welcome to you, sir. I also extend my warm welcome to Dr. B.K. Ravindra, Director of Legal Studies of Vivekananda Law College. Welcome to you, sir. I also extend my sincere welcome to Sri Manohar KV, President, and Sri Shyam Prasad Kaila, Secretary, and all the members of Core Committee of All India Moot Court Competition, whose dedicated efforts and commitment have contributed immensely to the successful organization of this prestigious event. I extend my welcome to the coordinators of Moot Society, Srimati Subhashini J. and Srimati Sangeeta S.M., and also extend my welcome to student coordinators of Moot Society of our college. I also take this opportunity to warmly welcome the Honorable Judges of Taluk and District Courts, Directors of Vivekananda Vidyavardhaka Sangha, members of the College Governing Council, members of the Parent Teacher Association, members of Alumni Association, representatives of various bar associations, faculty members, participants from various institutions, students, members of the press and media, and all distinguished guests gathered here this evening. Your gracious presence has truly made this occasion grand success. Thank you all, and once again a warm welcome to one and all.
Thank you, ma'am. Moving forward, now I respectfully invite Srimati Sangeeta S.M., Faculty Coordinator of Moot Society, Vivekananda Law College, Puttur, to present a comprehensive report of 3rd All India Level Moot Court Competition 2026.
Good evening, one and all gathered here. Good evening to the dignitaries on the dais and off the dais. It's my immense pleasure to read the report of 3 days 3rd All India Moot Court Competition 2026. Vivekananda Law College, one of the prestigious institutions in Dakshina Kannada, intended to host 3 days 3rd All India Moot Court Competition from 8th May 2026 to 10th May 2026. Day 1. On 8th May, that is the first day of the event, which was started with the registration procedure from 3 p.m. and 20 teams from all over Karnataka have registered. Following the registration, banner drop and the flash mob was successfully commenced. Researchers' test was conducted on the same day by 5:30 to 6:30 p.m. Day 2. The preliminary rounds of the moot court competition took place on the second day, that is on 9th May 2026. Total 5 court halls were there and each hall containing 4 teams. 2 rounds were there as preliminary round 1 and preliminary round 2. Judges for the preliminary round were Shri Girisham, Shri Divakara Nedvanaya, Shri Shambhu Bhatt, Shri Krishna Murthy, Srimati Manasa Hegde, Shri Mahabala Shetty, Shri Dayananda Rai, Shri Rajaram Surambail, Shri Manohar KV and Shri Shyam Prasad Kailar. Post lunch, there was an exclusive interaction session by Honorable Justice 𝐻𝐿 Judge, Supreme Court of India, and Professor Dr. C. Basavaraju, Vice Chancellor, Karnataka State Law University, Hubli, with the student community. Inaugural program started with the introduction of guests who offered flowers to Bharat Mata, followed by national song and the national anthem. Dr. Akshata AP, principal of our college, welcomed the guests and the gathering. Honorable Governor S. Abdul Nazir Sir inaugurated the session by lighting the lamp. Honorable Justice 𝐻𝐿 Judge, Supreme Court of India, addressed the gathering. Guest of honor for the program, Professor Dr. C. Basavaraju, Vice Chancellor, Karnataka State Law University, Hubli, addressed the gathering. Vivekananda Law College's Law Journal, Legal Spectrum, an edited book, was released by His Excellency Shri Abdul Nazir, Governor of Andhra Pradesh and former Judge, Supreme Court of India. The program was presided by Dr. K.M. Krishna Bhatt, Secretary, Vivekananda Vidyavardhaka Sangha Putturu, had introduced the background of the college and the importance of the big event. Shri Manohar KV, President, Core Committee, All India Moot Court Competition 2026, rendered the vote of thanks. The inaugural function was organized in the evening by 3:30, was prolonged till 5 o'clock. Dignitaries invited for the inaugural session as a special invitee was Shri 𝐻𝐿 Senior Advocate, Supreme Court of India. Shri Surendra Kiniji, President, Governing Council, Vivekananda Law College, was present in the event. Dr. B.K. Ravindra, Director of Legal Studies, Dr. Akshata AP, Principal, Vivekananda Law College, were also present in the event. The program ended with the national song and national anthem by 5:15 p.m. The program was emceed by Divya Das of 3rd LLB and Moot Court Coordinator. The very next event was quarterfinals. Total 8 teams were selected to the quarterfinals. Judges for the quarterfinals were Shri Narasimha Prasad, Shri Mahesh Kaje, Shri Naveen Bannintaya, Shri Subramanya Kumar Agartha, and Shri Udayananda A, Shri Ravindranatha P.S., Shri Shashikumar Kalluraya, Srimati Manasa Hegde. Followed by cultural events, the theme of the cultural program embellished with the culture of India. After the cultural event, quarter-final result was announced. Total 4 teams were selected for the semi-finals round. Day 3. The semi-final round commenced on 10th May 2026 at room number 002 around 9 a.m. Total 4 teams were competing and showed their legal excellency. From that, 2 teams selected for finals, which commenced around 1:30 at Moot Court Hall. The teams competed with the great spirit. The judges for the semi-finals Moot Court competition were Srimati Josna D, Additional 3rd Additional District and Sessions Judge sitting at Srirangapatna, and Sri Gopalakrishna T, Additional City Civil and Sessions Judge, City Civil Court, Sri Shivananda Perla, Senior Public Prosecutor, CBI Office of the SP. The final round of the moot court competition was adjourned by Honorable Justice Indiresh E, Honorable Justice V. Srishananda, Honorable Justice Tyagaraja Inavalli, Sri M. Rammohan Rao, Sri Premanath K, advocates. Thank you one and all for the opportunity. Thank you again.
Thank you, ma'am. A competition of this stature is shaped by the experiences of those who participate in it. Now, I would like to invite any two of the participants to come forward and share their reflections of the competition.
Distinguished judges on the dais, off the dais, participants, mooters, students, faculty, everyone present here, a marvelous evening to one and all. I, Hafsa, a student of University Law College, Bangalore University, gives a tribute to Vivekananda Law College for organizing and executing such a commendable event, for organizing an event of 3rd edition of the moot court competition. I am here not because I'm a finalist, guys, but because to highlight the efforts and hospitality of the Puttur people in the infamous weather of the rains and the natural calamities happening. Every student of the faculties, indeed, I'm sure this whole event, we will be, of course, be very pleased by the judges, but I am here to thank each and every student who is present here, who has been accompanied us throughout the event. Our hospitalities and the accommodation facilities were well organized. When I say this, I'm also reminded as a mooter, I'm in my final year now. I'm just 2 months away to be enrolled as an advocate. This is my 18th moot court competition, and also maybe I'm a finalist today. I might win a trophy, but what I want to leave when I leave this dais is that maybe we may win the prize or a trophy today, but I wish every mooter tomorrow may win the case. By this, I say all the very best to all the mooters. Thank you so much for having us.
Greetings, dignitaries on the dais and off the dais. I'm Aditya Patil from Karnataka State Law University's Law School. Well, it is my first moot, and the first moot has set us such a high standards that every single moot I'll be going from now onwards. I mean, I don't know how much expectation I need to keep from now onwards. First of all, I would like to thank the faculty coordinators, especially Subhashini ma'am. From the day one itself, ma'am has been coordinating with us very in such a manner that it feels like home to us. Every single time, whenever we ask, whenever we come with the queries, ma'am has always guided in such a warmth manner that it felt good to us. The second thing is hospitality. There's no doubt that the hospitality of the Vivekananda Law School is at the top at its peak. Every single volunteer, every single person, even every single students, they were so kind. They were guiding, especially our team companion. A big shout out to Aditya, our team companion. He was been with us from the beginning to the end. Every single companions, I would heartily thank for them. The third thing is the food. Although I belong from North Karnataka, the food here was just amazing. At the last, the bench which we just saw in the finals. First of all, it's my honor to be being in the finals in the first moot, and as a researcher, it's my privilege to be along with these two such good mooters of my team. That's all right.
greetings to everyone here. I wouldn't want to prolong the feedback that I'm going to be giving, but this is the first time I was ever picked from the bus stand of the city that I arrive in, and then be brought to the college, and then to the hotel. So I think the point about hospitality, we all agree with that. And also I would like to give a huge shout out to our escort as well, Mr. Prithvi Sagar. He was always there with us. Any help that we ask him, a very courteous man, and he genuinely motivated us all the time to give our best. And we feel very overwhelmed with the amount of affection and hospitality that is given to us that I'm not able to articulate myself very well right now. Thank you so much.
Thank you, participants, for sharing your experiences. Moving forward, it is a moment of great pride for us to honor those who have excelled the heights of legal profession. Now I request Honorable Mr. Justice E.S. Indresh to felicitate Shri Rajashekar Hiliyar, Advocate, High Court of Karnataka and Honorable Member of All India Stock Witness Reforms Expert Committee, Supreme Court of India. Advocate S. Rajashekar Hiliyar is our proud alumnus hailing from Ilantila village, Belthangady Taluk. He began his legal practice in 2004 at High Court of Karnataka with extensive experience in diverse areas of law. He has appeared before the Honorable Supreme Court of India, the High Court of Karnataka, family courts and civil and criminal courts across Karnataka, and various tribunals including the Debt Recovery Tribunal, Karnataka Administrative Tribunal, NCLT, and Karnataka State Consumer Dispute Redressal Tribunal. He has also handled matters relating to civil, criminal, cooperative, banking services, consumer and negotiable instrument law. Over the years, he has served as Senior Panel Counsel for the Union of India before the Honorable High Court of Karnataka, and also has been the panel advocate for several important institutions including Karnataka State Election Commission, KPSC, KSRTC, Karnataka Bank, DCC Bank, LD Bank, and Karnataka State Cooperative Apex Bank Limited. Shri S. Rajashekar Hiliyar, Advocate and our proud alumnus, has sponsored us new air conditioner equipments to our college Moot Court Hall. His voluntary service clearly shows his good heart and benevolent approach and the respect he tenders to our Vivekananda Law College. Thank you very much, sir. We are also humbled by your kind gesture. We, the management and faculty members of Vivekananda Law College with Alumni Association, take the privilege in honoring our proud alumnus, Shri S. Rajashekar Hiliyar, Advocate, High Court of Karnataka, for being appointed as Honorable Member of All India Stock Witness Reforms Expert Committee by the Honorable Supreme Court of India. Srimati Akshata AP is the principal of our college. It gives us immense joy and pride to announce in this platform regarding her recent academic excellence. Madam has been awarded with PhD, a doctoral award for her thesis, a critical study on resolution of commercial disputes in real estate sector through ADR mechanism by Karnataka State Law University, Hubballi. This thesis is done under guideship of Dr. Taranath, Principal of SDM Law College, Mangalore. A heartfelt congratulations to you, ma'am. Yatra naryantu pujyante, ramante tatra devataha. Where women are honored, divinity blossoms there. In this regard, I request the Moot Court faculty coordinators, Srimati Subhashini SM, Srimati Sangeeta SM and Subhashini J, to honor the Akshata ma'am in traditional Indian way. Moving forward, we are deeply honored to have with us Honorable Mr. Justice E.S. Indresh, Judge, High Court of Karnataka. Now I request Mr. Dilip P.S., Student Coordinator of Moot Society, to read out the profile of Mr. Justice.
Honorable Sri Justice 𝐷𝐿 𝐶 Indresh was born in the year 1972, had his early education at Pandavapura town, secured his BSc degree from Yuvaraja's College, Mysore, obtained degree in law from Sharada Vilas College, Mysore, and LLM from University of Mysore, secured first rank in the Constitutional Law branch. Sri Justice enrolled as an advocate in the Karnataka State Bar Council in the year 1996, joined the office of Srimati B.V. Nagaratna, who is presently serving as a judge of Honorable Supreme Court of India, practiced in different branches like service, labor, education, etc. Served as panel advocate for Mysore Sugar Company, KSFC, Karnataka Marketing Federation, Oriental Insurance Company, United India Insurance Company, etc. Honorable Justice was also into teaching, being guest faculty at Sharada Vilas Law College, Mysore, and later worked at Savanoor College of Law and Bangalore Institute of Legal Studies at Bangalore. Honorable Justice was a regular faculty at Karnataka Police Academy and had given lectures on the preventive detention matters, particularly Gunda Act and Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. Honorable Justice served as government pleader and as additional government advocate between 2009 till elevation, and is appointed as an additional judge of Karnataka High Court on 7th February 2020 and permanent judge on 25th September 2021. Sir, I am deeply honored to welcome you. Thank you.
ಎಲ್ಲರಿಗೂ ನನ್ನ ನಮಸ್ಕಾರ. Honorable Justice V. Shishananda, Honorable Justice Tyagarajan and Inavalli, my brothers at the High Court of Karnataka, brother and sister judges from the District Judiciary, the Dr. B.K. Ravindra, Director of Legal Studies of this institution, Sister Dr. Akshata A.P., Principal of this institution, distinguished guests on the dais, of the dais, students, faculty, non-faculty, then my dear students, participants, print and media, and the learned advocates, those who are present in this occasion. So firstly, I should congratulate the college for having conducting the third All India Moot Court competition. One thing I would say, it's not that much easy to conduct a national moot court. Firstly, insofar as the entire the aspects has to be started just even 1 month before. You have to do hard work insofar as the committee is concerned. And also it requires a lot of financial aspects, that also I am aware, and the coordination from the students. But one thing I will clear that by conducting this type of the moot court, students of the institution will be well aware about the professional aspects, and that apart, the network with the fellow students, those who are participants, will continue. And moreover, one thing, dear friends, insofar as nowadays we will see, you need to have a courage to appear before the learned judges. It's not that much easy many times. We have witnessed in our finals. So what I am saying that insofar as the profession is concerned, when we have joined law during 90s, insofar as legal education is in India is concerned, it is not by choice actually. Sometimes by where we were not able to get the appropriate course, whether it's the natural science or the social science. We have joined the law. But nowadays it is very quite different. Now you will join the law as a professionalist. When we were the students of law, most of our teachers were part-timers, and they are very interested in their every day they work at court, and they are not in a position to give more importance. Insofar they are not inclined to insofar talk to us also sometimes, barring few. But nowadays, insofar legal education in India is concerned, is transformed a lot, where the teachers will take care of you, and apart from all those things, every day you will interact with them, and many the functions will be conducted by the college, inviting the learned senior advocates, good academicians, learned judges, those who can, from the trial side up to the Honorable Supreme Court, and you will get to know all these things insofar as by joining a good institution. This is one such institution which is imparting very nice education, legal education in Karnataka, insofar as apart from the premier institutions in Bangalore. I am well aware about the same. I should be very grateful to the management and the principal and the director is as such. Secondly, dear friends, insofar as the moot court is concerned, you have to prepare. Not only preparing for looking into the facts and what is the law to be applicable to the facts of the case. Moreover, you will be exposed to the how you have to argue the matter before the learned judges, and you have to inculcate what are the nuisance of law is concerned. And nevertheless, all these things, what I am saying that you will become intellectually sharper. This what by participating, or just you are looking into the not only participation in so far as the attending the moot courts, you will come to know all these things. One thing, dear friends, so far as the profession is concerned, I will wish that you have taken a noblest profession. Definitely it is not like earlier, where nowadays even on monetary wise also you will be well placed compared to us, provided as Honorable Justice P. Vishwanath Shetty sir was telling when I was young in 98, if you work like a donkey, then you will become a horse in the race. See, donkey means just hard work, integrity, coupled with reflective thinking. If you have a reflective thinking in your mind, definitely you will come up in the profession. Reason is, for both the sides in the litigation, facts will be similar. But how you will read the facts to do good for your client, or how you will argue the matter based on concepts or the doctrines or the precedents is concerned, and what is the law governing a particular field is concerned. These are all the things you learn insofar as by looking into the factual aspect is concerned. This is what I would like to say, that if you prepare yourself insofar as the material facts is concerned, not necessarily that you have to understand the facts, what is the material facts involved in the case is concerned. See, that's why I shall be very grateful to the institution for having the problem which is coupled with both the Hindu Succession Act with the Hindu Marriage Act today, what we have witnessed. And of course, both the teams did well, but understanding the material facts in a particular case, it makes a lot of difference. Because reason is, dear friends, insofar as the upcoming lawyers is concerned, maybe not necessarily you may be a very good language, maybe you have a technologically advanced compared to us, and the judgments that you will look into it in a fingertips, and you are able to make out a case in your at the time of arguing the matter. But one thing is very pertinent to mention here, that insofar as nowadays I will tell all the students, please join immediately after course a good senior. You got my point? Good senior. If you join good senior, be with them for at least minimum 3 to 4 years. Don't become independent within 1 year or 6 months or like that. Recently I had an occasion to, I think last 3-4 months, one of the council representative madam says, my senior will address the argument at 2:30, my lords, please take it up 2:30. I say, sir, my senior advocate will come. Senior advocate came at 2:30 and saw he is also young. I saw then, then he argued the matter. Of course, he has given some citation which is in favor of the other side by looking into the head notes. They never read the entire judgments and the proposition of law, what they have to produce. It was very inaccurate. Then I asked him, when did you become senior? When did you pass law? He said, sir, 1.5 years has passed from NLS Bangalore. Now I have 2 juniors of 6 months. Sir. See, that cannot be ground. See, what I am saying, irrespective of whether we have studied in NLS or any premier institutions Bangalore or institutions like any other, like the rural part of Karnataka, one thing is very clear, dear friends, insofar as the legal profession is concerned, common sense, interaction with others, how you will read the books, and moreover, how you will erudite yourself insofar as involving in a matter is concerned. These makes lot of difference is concerned. Because I am from Mandya district, whenever the clients will come from Mandya district or Mysore, normally clients are very good in Karnataka Land Revenue Act and Land Reforms Act. They have to ask me, sir, please read section 62 of the Land Revenue or 133 of Land Reforms Act or 161, because nowadays, dear friends, unlike us, your client will look at from the video conference how you will argue the matter before the court. They will test you. It is not that now, because that should be there in your mind. Unless you make out a point before the court with the established principle of law, or assisting a court in a manner which is known to law, or make out a case insofar as with the right proposition of law, then it is very difficult. As insofar as, dear friends, as you know, insofar as the professionalism is concerned, our is a professionalism where integrity, dedication, and a profound sense of the professionalism is there, perseverance and empathy. See, that should be there in your mind, dear friends, when you are arguing the matter before the court. Don't be under the impression that you know everything, or else that everyone who is sitting behind you is also know everything. If someone question you to me today, sir, how much that you know law, because you are nearer to Arabian Sea, I will say, I know only a drop of water in Arabian Sea. Because insofar as law is concerned, dear friends, I would say, not only you are expert in the field of law, apart from common sense, perseverance, you must be good in natural science, social science, even mathematics, whatever maybe the thing is concerned, you might, because nowadays, because of technology is concerned, you need to have knowledge about everything, maybe insofar as the particular case is concerned. And next, insofar as the students are concerned, dear friends, I appeal to each one of you, please read the biography of great jurists in India. Apart from Patanjali Shastri, Venkatramaya, Subra, or Vivian Bose, or Honorable Justice P.N. Bhagavati, Krishna, why I am saying all these things, or even jurists also like Motilal Setalwad, C.K. Daftari, or Nani Palkiwala ji, Soli Sorab ji. Please read their biography. Because today we have survived, dear friends, for 75 years. I would say because of the Supreme Court being a guardian of our rights has protected the Constitution till date. That's why today we have survived as the biggest democratic country. Therefore, please read how the judgments have come up, whether it may be from 1951 to till date, how the law has been evolved by the Supreme Court, how the judgments have been rendered by the honorable judges by applying the interpretation of the text and context. text and context plays a vital role when we will apply the doctrinates of the interpretation of statutes. Therefore, I am appealed each one of you, please read the biography of great our the jurist, whether it's M.C. Chagla or the Subra or whoever may be the thing. Each one of them will be an inspiration for us. So, and nextly I would say, whenever you find time, please go to court hall, whether it's a Puttur court or Mangalore court or the Bangalore High Court or the Supreme Court. Whenever you will find a friend, please listen to the arguments advanced by the learned senior counsel. How is their prepare the case at the time of the argument is concerned. Many things, dear friends, we learn from others. It is not only text will give knowledge for us, even by looking into others also, how they will argue the matter, how the proposition of law will be advanced by the learned counsels in the court. These are all the things we learn only by looking in the court. And these are all the things nowadays I would say. And nextly, dear friends, insofar as nowadays, of course, all of your, I think yesterday also, I think morning, many things have been stated about the legal profession. Insofar as the way of the legal luminaries is concerned, what I am saying that you must be a mastering about the facts of the case and how to apply the law to a particular facts and how the interdisciplinary learning social commitment is there, because we are all social engineering, we are also engineers of the society, to what best we can do to the society and what this country has given to us, how we have to give back to this country, because as Abdul Kalam ji say that you need not do great things to this country. By doing very small things for this country, you can do achieve. Very small things. We are also, we need not become the Prime Minister, President, or the judges of the Supreme Court, or Chief Minister. We need not become higher. Even a common man, we can do wonder insofar as the societal interest is concerned. Have this in your mind is concerned. And in nowadays, insofar as the technological understanding is concerned, the students, AI is there, and many of them are, because one thing is, dear friends, it is only a tool for you, for your, the preparation is concerned. One thing is clear, dear friends, nothing is replacement for our brain. We have to apply our brain to a particular case, how we have to prepare the, for the case is concerned. And that's why I'm always tell the students, don't become slave to the technology by looking into the, some few judgments without knowing the background of the case as such and how the law has been evolved from 1951 till date. These are all the things we must know before we are, giving any judgments to the court at the time of our argument is concerned. Because it's only an access to the information, that's all. It is only an access to the information insofar as IT is concerned. But however, if you become more inclined to the AI or insofar as the recent technology is concerned, then you will lose the creativity. You will lose the creativity. You will lose the innovation in your mind as such. And independent thinking will go away from you. Unless you have to apply your mind to each case based on the what law says that, then it would be very difficult. So that's why what I'm saying to each one of you, dear friends, by attending this type of the moot court is concerned, today we have witnessed how the arguments have been advanced. Sometimes the judges will also argue with the advocates, and many times it will happen. Argue means how we have to extract the things from your side, because many of the things rights are now crystallized. How you understand the law insofar as the facts is concerned. That's why normally it will happen, and I wish those who are going to be win, the good for you, and those who are participated, don't feel that you lost everything. But one thing is, dear friends, we learn forever. And there is no, I think, impediment for me to say that every day we are all the student of law. We have to learn many things, dear friends. We even take for an example, when we are sitting in the bench, many judgments will be rendered by the learned councils. Then we will be also wonder how the law has been evolved by the Honorable Supreme Court or various high courts is concerned. So that should be there. For need to have a good bench, always we need a good lawyer. The nation requires good lawyer because if you look at the framing of the Indian Constitution is concerned, most of them are from the legal fraternity, whether they were Alladi Krishnaswamy or Ambedkar ji, Kunzru, or whoever maybe thing is concerned. They are all very expertise because their foundation is very good. If your foundation is good, then it is easier for you to understand and come up in the profession. Please have an inclination to work with a good senior for considerable period and advance your knowledge is concerned. And one thing should be there in your mind, that the creativity in your mind. Creativity should be there. Because though all of you know the basic structure is evolved in 𝐾𝐲𝐿 Bharati, but it was not, it was there in Honorable Justice Mudolkar judgment in Sajjan Singh case, 1965 Supreme Court. See how it was, of course it was advanced in 𝐾𝐲𝐿 Bharati. All of you know very well, I need not tell now on this occasion. And good luck for everyone. And I shall be very grateful to the institution for having invited me. And thank you one and all. And one thing I will clear, love your parents, respect your parents, take care of their parents as long as they are with you. And also, this country has given everything for us. See, we are all here. Air is belong to this country. Land is belong to country. Do something for the country. Don't do, or it is including me also. I don't want to do anything against the country's concern. Love your country. Thank you, one and all.
Sir, we are immensely grateful for your valedictory address. We are equally honored to have with us Honorable Mr. Justice V. Srishananda, Judge, High Court of Karnataka. Now, I request Mr. Dilip P.S. to read out the profile of Mr. Justice. We would like to announce the prizes of today's event.
One small modification in the program. We are told that one of the teams who have reached the final have to catch the train at 6 o'clock. So the talk of mine is postponed after the distribution of the prizes for the winning and running, winner-up and runner-up teams only. Rest of the things it will follow. So the modification, now the announcement will be there, the finalists, then who is the winner and who is the runner, they can come up here, take the prizes and go. If there is any further, yes. All right, okay. The program is scheduled as per the schedule now because they are staying up. They are not going on the 6 o'clock train. Madam, please. Whoever wants to introduce, if I think I don't need any introduction, let me straight away come to the point. Only thing is I have disappointed the person who has prepared the introductory note. Nevertheless, good evening to one and all. My dear brothers, Justice Indresh, Justice Invalli, other dignitaries on and off the dais, district judiciary members from the Karnataka State Judiciary. Incidentally, she is also daughter of the soil, 𝐂𝐗𝐫. She is from Puttur. Respected senior members of the bar, my dear students and budding advocates, faculty member, principal. Indeed, it was a very good third national moot court competition. The word has come international. Soon, I think the Puttur will be hosting the international as well. Participants had prepared well. They had presented their case study like a seasoned advocates. The preparation was really good, though there were searching questions for them. Brother Indresh has covered major portions of the nuances of the legal profession, requirement of you in the society, what are the roles to be played by you, like an elderly person, a fatherly person he has advised. In fact, many of his advices I also cherish, though I am in the evening of my career as a lawyer and a judge. Many of the autobiographies that brother mentioned, I am yet to go through. One word that actually sounds in the same manner, but what is required for the noble profession is fashion and passion. In the beginning, everybody will have FASHION, fashion. But the profession will hold its your hand if you are working with PASSION, passion. So this is the key for success. I have a son who is an advocate now. I was a son of an advocate, so I have dual roles to play. One thing that is one should bear in the mind is the shortcut between the 2 points, shortest distance between the 2 points is called straight line in geometry. That is the truth, both in geometry and real life. Those of you can follow Kannada, this will be more apt. ಎರಡು ಬಿಂದುಗಳ ನಡುವಿನ ಅತ್ಯಂತ ಸನಿಹದ ದೂರವನ್ನು ನಾವು ಸರಳ ರೇಖೆ ಎಂದು ಕರೆದೆವು ಅಂತ. ಯಾರು ರೇಖಾಗಣಿತ ಅಂತ ಕಲ್ತಿದ್ರಿ ಅವ್ರಿಗೆಲ್ಲ ಗೊತ್ತಿದೆ ಸರಳ ರೇಖೆ ಅಂತ. ಯಾವುದು ಸರಳವಲ್ಲವೋ ಅದು ಇಂಗ್ಲೀಷಲ್ಲಿ ಆಬ್ಲಿಕ್ ಆಯಿತು, ಕನ್ನಡದಲ್ಲಿ ವಕ್ರ ಅಂತ ಆಯಿತು. ವಕ್ರ ಆಗ್ತೀರಾ ಬಿಡ್ತೀರಾ ನಿಮ್ಮ ಇಚ್ಛೆ. ಸರಳವಾಗಿರೋದು ಅಂತಂದರೆ ಸತ್ಯವನ್ನು ನುಡಿಯೋದು ಅಂತ. ದಟ್ ಈಸ್ ದಿ ಒನ್ ವಿಚ್ ಫಲ್ಕ್ರಮ್ ವಿಚ್ ಹೋಲ್ಡ್ಸ್ ದಿ ಎಂಟೈರ್ ಸೊಸೈಟಿ. In Dikshitulu versus State of Andhra Pradesh, Honorable Supreme Court had to deal with several other aspects of the matter. While so dealing with, the Honorable Supreme Court understood what actually the dharma means in the Indian context, not only in the Indian context, what it means to the society. While so dealing with the said aspect of the matter, the Honorable Supreme Court said, dharma is the one which sustains the society, which works out for the development of the society, which maintains the society. This is what the dharma meant for. My dear friends, how many of you heard many convocation addresses, prepared speech delivered by the governors, dignitaries for each of the universities? If you look back, the country had what is called Gurukula system. When the people across the world were not even having any idea of civilization, we had the universities in this country. Mind this. Those values we must re-inculcate is what the ultimate idea one has to have by becoming an educated. Unfortunately, today what we have are the persons who are literate and not educated. There is a difference between a literate and an educated. Two professions are called noble professions. One is, of course, the law profession. The other one is the profession of doctors, medical field. These two professions are called noble professions. Unfortunately, whether both the professions are retaining its nobility, I have my own doubts. Full stop. Why? Why I say full stop? Why I say full stop? We don't want to ponder further over that. You know the reasons for yourselves. We had the seat of Vikramaditya in this country. Today we are talking of the environmental law. We are talking of the justice to the animals, justice to the environment. We had seat of Vikramaditya in Ujjain, where there was a bell. In that bell, whoever rings will be given the justice. Seat of Vikramaditya, person used to preside and deliver the justice. Unfortunately, today, noble profession has become Nobel profession. That's why I said full stop. Let us not worry about the negative things in the system. In the moot court final round also, I emphasized this aspect of the matter. Such a huge country, diversity in the life. Soon after Britishers left us, we did not have a law of our own. We could not think of how our country would be ruled. We had the Constituent Assembly. We had the members there across the country, including the ladies. Several sections of the society participated. We framed Constitution. Our own Constitution we framed. A written Constitution which is an exclusive piece of the work. Well, from 1950 to 2026, lot of changes have taken place in the society. Developments have taken place. Business, globalization, digitization, several challenges have come up. Whether we are in a position to encapsulate all those developments into our existing laws is a question, is a situation where we are working out. Mind you, for someone here, including me, Ramayana, Mahabharata, Bhagavad Gita, all these things may be the very sacred texts. No problem. You can have it. Some of us, Holy Quran may be the one which can be looked into. And for them it's a sacred. Some may believe in Buddhism, some may believe in Jainism, some may believe in Granth Sahib, some may have an affection and for them the sacred Grantha is Bible. Absolutely no worry. These should be well within our puja room. Once you step out of the puja room, once you come out of your house, the one sacred book one should have is the Constitution and Constitution alone. Meaning thereby, we respect our nation, we respect our Constitution, we respect our national emblems, we respect our national song, we respect the constitutional ethos from the bottom of our heart. We don't require any legislation that you should do it. It should be inbuilt. That is when this country is going to flourish. This is one aspect of the matter. It should not be put as a burden. It should not be imposed. It should be from within. This is what ultimately what is wanted. In the guise of freedom of speech, in the guise of other constitutional fundamental rights enshrined in Article 19, if you act against the ethos of the Constitution, naturally the law, penal laws will have to kick in and then consequences shall follow. Should we require a debate for that? Happy International Mother's Day for all of you. Do I have to emphasize, no, you respect your mother? It should be inbuilt now. That is the way one should go about it. So when you consider that this nation has given you the birth, this nation has given you to pursue your own whatever you wanted to, then this should also be considered as Mother India. The mother who gave me the birth from the womb. Likewise, this portion of the earth has given me the birth to live here, flourish here. Do we require a legislation for that? Do we require a legislation that, if you don't respect your parents, the property taken off from your parents will be returned to them? Shame on us, is it not? Therefore, there is a gap between the value system that we had in 1950 and value system what we have in 2025. 75 years has shown us what the Constitution wanted us to be and what we are. Therefore, I said, mere becoming the literate or the law graduate or some other graduate or a diploma holder is not the purpose of the education. For all other things, we look at the other famous quotes from the other countries. Look at that. What the others have told. Don't ask what the country has given to me. You ask what you have given to the country. How many of us are doing that? National waste, we are not preventing. National values being eroded, we are not preventing. Therefore, there is a time now. Every advocate tomorrow, every law graduate tomorrow, for that matter, every citizen of this country should not at any case suffer for what? For not enlightening ourselves with the knowledge. Knowledge is available in the form of books. Now it is a click of a mouse. We are talking of artificial intelligence because it has already crept in. I have a famous saying, whenever the AI seminars are being carried out, I would always say, the world is already suffering from natural stupidity and artificial intelligence. So we shall now remove the natural stupidity. Automatically we don't require artificial intelligence. It's as simple as that. So time has come. Technology, we are trying to catch up. We are taking the technology into our legal field as well. World is not suffering, in the words of Abdul Kalam, world is not suffering from violence of many. How many criminal cases are there in Puttur? What is the population ratio? World is not suffering from violence of many. World is suffering from silence of many. Encourage, take the courage, and then stand up and then say, sir, this is incorrect, this is illegal, this is violence. Don't suffer. That is when one would get the desired results under the Constitution. Article 21, what was interpreted in A.K. Gopalan, is not the interpretation today. Recently, as recently in the case of Puttaswamy, the Honorable Supreme Court has to require him to survey all those decisions right from A.K. Gopalan, then to the Keshavananda Bharati, Maneka Gandhi. All these things have come up. Why it has come up means it is capable of taking so much load irrespective of the developments that may take place. It can get itself into the framework of the Constitution and work for the betterment of the society, betterment of our nation. That is what ultimately the definition of Dharma as found in the state of Dikshitulu versus state of Andhra Pradesh. So what we have to look into is, come what may, let us stick on to the fundamentals. Having said all these things, all the teams have worked well, especially the finalists. They did well. It's a fact that they have been through and they have entered finals, and the moot proposition was also quite good. Preparations were really good, but one word of advice, if you want to take it, don't take the problem by itself. Go to the fundamentals. Understand the substantial questions that is involved in particular moot proposition. On the factual aspects, on the legal aspects. Before that, you should know what are the substantive laws that is in the place in this country, laws that are existing. In the moot proposition itself, they would have indicated you may have to look into these substantial laws. Then the procedural laws. So procedure is one aspect of the matter. Procedure is handmade for this dispensation of the substantive justice. Justice is not only done, but seem to have been done. These are all the principles one has to bear in mind. While so preparing, one advice, if you want to take it, is read every word religiously in the moot proposition. Many times the answer itself available there. Lack of reading or improper reading or lack of understanding factual aspects of the matter may take you into a different result by itself. So my request to the mooters here is, we have seen first mooter who are the research assistant here who spoke, and we have also seen the 18th mooter who participated and presented the case well today. Two contours we got it. Both of them, all of them rather, did well to their best of their capacity. This is a moot proposition, therefore winning, losing is one other aspect. How you presented your case, how you presented your point of view matters much. See, if the factual aspect as per the decided case law is in a particular party's favor, naturally they will get to know they are in an advantageous position. For a loose ball, anybody can hit a sixer. If you are hitting a sixer to a bouncer, then you are the good batsman. That should be the spirit with which one has to prepare. My dear friends, you are all youngsters. You have got a long way to go. I am in the evening of my career in this field. My remaining life, though I am available for the fraternity on these type of events, life has got other purposes also. I have already started in that direction, made few attempts also, little bit successful as well. So I may have some more time to look into all those aspects of the matter post-retirement. But you are the persons. You are all the persons who have to take it. This one day that we have spent in Puttur would not come back to any one of us. Any one of us. One evening is over, one sunset is over, one day is gone in your life. All of us have come back to this, all of us have come here with a boarding pass in hand. Please mind this, we have a boarding pass in our hand. Date is fixed, time is fixed. It is in the sealed cover. And that flight, whatever that we are going to get back, is never late. Unfortunately, it has no seat number 11A also. So therefore, I am a little selfish person. Youngsters here who have participated and reached the final, those who could not have had the experience of participating in the moot, day is not good, may not be good for you. Better luck next time. Winners are not the persons who are the best. Losers are not the persons who are worst. It's a day of their choice. It has happened. Ultimately, it is the values which should triumph and values which should be cherished. So they had the participation. All of you have spent, couple of them have spent about 3 days. We have spent about a day. It is, I am investing as a premium. I want dividend back. What could be the dividend? A girl there, a boy here, would be standing here 20 years down the line when the Vivekananda College holds the international moot competition. They would be speaking from this podium and then cherishing this value and taking it further. All the best. Thank you.
Thank you, sir, for your insightful and enriching words. We are equally honored to have with us Honorable Mr. Justice Tyagaraja Narayan Inavali, Judge, High Court of Karnataka. Now I request Honorable Mr. Justice T.N. Inavali, sir, Judge, High Court of Karnataka, to kindly address the gathering.
My respected senior brothers, Mr. Justice E.S. Indiresh, Mr. Justice V. Srishananda, special invitee Sri G. Jagannath Rai, President of the program Sri Srinivas Murthy Konda, Senior Advocate, Andhra Pradesh High Court, Sri Vijay Narayana K.M., Correspondent of this institution, my Guru, Professor B.K. Ravindra, my esteemed sister Akshata, Principal of this institution, another sister Srimati Josna, former Principal and presently she is an additional District Judge, Senior Advocates Sri M. Ramohan Rao, Sri Premanath, and all the advocates from Puttur, esteemed faculty members, dear students, participants of this esteemed moot court competition. You all know when 3 sitting judges are sitting together, it is called full bench. 2 senior brothers have already talked, so being the junior member of the bench, my endeavor is only to say I agree with them, I endeavor their talk. But as a guest, I want to say something. It gives me immense pleasure to be here today among bright, enthusiastic young minds at the culmination of this moot court competition. Moot courts are not merely academic exercises, they are crucibles in which the skills of advocacy, reasoning, and jurisprudential insight are forged. In my experience, law is as much about logic and precedent as it is about empathy and justice. The courtroom is a space where words carry the power to project rights, uphold liberties, and shape society. Competitions like these help you, the future legal professionals, to practice the art of persuasion, to learn to think on your feet, and to appreciate the delicate balance between law and equity. I urge all the participants to take this experience beyond the competition. Whether you succeed today or not, remember that every argument you have presented, every objection you have raised, and every point you have defended is a step towards honing your professional skills. Law is a lifelong journey of learning, questioning, and involving. I would also like to remind you that the essence of advocacy is not to win alone, but to serve justice with integrity and diligence. Your conduct, ethics, and respect for the law will define your legacy more than any judgment you win. Finally, I commend the organizers, faculty, and students for making this event possible. Events like these reflect the vibrance of our legal education and the high standards we aspire to go in legal profession. To the participant, enjoy this moment, reflect on your performance, and continue to nurture the skills and passion that brought you here. I am confident that many of you will go on to make significant contributions to our legal system. Thank you, and I wish you all the success in your future endeavor. Thank you.
Thank you, sir, for your enlightening words. Now I request Sri G. Jagannath Rai, President of Bar Association Puttur, to share a few words with the gathering.
Respected Lords of High Court of Karnataka, distinguished judges, President of the function, dignitaries of the dais, Principal of the college, faculties, advocates, Bar Association members, and dear students. Good evening to all. It is a great pleasure and privilege for me to be present here today as a special invitee for this Moot Court program organized by Vivekananda Law College. First of all, I congratulate the organizers and all participating students. Moot Court is not just a competition, it is a practical training ground for future advocates and judges. It helps students develop confidence, legal knowledge, research skills, drafting ability, and court etiquette. Today's law students are tomorrow's protectors of justice and constitutional values. Success in the legal profession does not depend only on marks of degrees. Discipline, honesty, preparation, and respect for the court are equally important. I request all students to actively participate in Moot Court debates, legal aid programs, and internships. Every argument you present here will strengthen your advocacy skills for the future. The legal profession is a noble profession. An advocate has a responsibility to protect truth, justice, and the right of the society. Always remember, the law is not merely a career, it is just a service to the people. I also appreciate the efforts of the Bar Association and faculty members for encouraging young law students through such programs. I wish all participants and the very best for their future careers. May you become successful advocates, judges, and responsible citizens. Thank you one and all.
Thank you, sir. Moving forward, as a token of our immense gratitude and profound respect, we would like to honor our esteemed dignitaries on the dais. May I request Dr. B.K. Ravindra, Director of Legal Studies, Vivekananda Law College, Puttur, to honor the distinguished guest of today's program, Honorable Mr. Justice E.S. Indresh, Judge, High Court of Karnataka. Thank you, sir. May I now request Sri Manohar KV, Advocate, to honor the chief guest of today's program, Honorable Mr. Justice V. Srishananda, Judge, High Court of Karnataka. Thank you, sir. May I now request Sri Srinivas Murthikonda, Senior Advocate, to honor the Chief Guest of today's program, Honorable Mr. Justice Tyagaraja Narayan Inavali, Judge, High Court of Karnataka. Thank you, sir. May I now request Sri Vivekananda K.M., Correspondent, Vivekananda Law College, Puttur, to honor the President of today's program, Sri Srinivas Murthikonda, Senior Advocate, Andhra Pradesh High Court, and National President of Akhila Bharatiya Adhivakta Parishad. Thank you, sir. Moving forward, we have with us today Sri Srinivas Murthikonda, Senior Advocate, Andhra Pradesh High Court, and National President of Akhila Bharatiya Adhivakta Parishad. Sir did his BSc graduation from Hyderabad, Master degree in Physics from Delhi University. Sir is also a law graduate from Hyderabad Osmania University. While doing his law graduation, he worked in Telugu and English newspaper. He was also a legal reporter for Hindu newspaper for 2 decades. He is also the experience of working in civil liberties organizations, and presently he is the national president of Akhila Bharatiya Adhivakta Parishad. He is also designated senior advocate, presently practicing in Telangana and Andhra Pradesh High Courts. Sir, I kindly request you to deliver the presidential address.
Sabhaku Namaskaram. Dignitaries on the dais, and young advocates. Now time is running out. Know that I'll be keeping in view that. It's a privilege for me to be here in the presence of these people, especially full bench, as I said that. Usually in courts, when we argue before full bench, we have to be careful. And when we argue along with advocates, say the batch matters. Sir, please, I adopt the arguments of so-and-so, so-and-so. So here I can't say that because they are learned judges. Before starting, all of you are young advocates. In a lighter vein, you must have heard about it. One young advocate went to a court for 1 week. Then he met his friends. Asked to who knows the law. Said, my senior alone knows the law. No one else knows the law. After 1 month, again friends met him. He was saying that my senior doesn't know any law. Other side advocate knows the full law. Then after 1 month again, he met the friends and relatives. Said, both advocates don't know law. Only judge knows the law. After 3 months, again he met. I said, what is about this? Neither the judge nor the advocates know. I only know the law. So that's what the young advocates tend to do it lightly. As learned judges have said, we have got a social responsibility not only to participate in dispute resolution mechanism. Remember, as advocates, we mold the social opinion. Social discourse is molded, guided by us. Society looks forward towards us for certain guidance. In that process, we articulate their anxieties, we search for the solutions. In that process, we mold. That's the reason society respects us. Gandhiji used to search for lawyers all over the country, and all of you will be giving out names from Karnataka who has participated, advocates who have participated in freedom struggle and who have literally made a new direction to the freedom struggle. As his lordship said regarding dharma, What is justice? Compassion within the four corners of law. Law is the letter of dharma. Justice is the spirit of dharma. When we speak about law, I know all of you have got the Manupatras, SCCs, and all these things. Please don't confine yourselves to that. Look into every judgment given by learned judges. There will be a logic into it. There will be logic into it. Look into the basis of that logic. Then we should understand how the law has evolved. Then we'll understand. Let us be frank about it. All of us are under the influence and guided by the Anglo-Saxon jurisprudence of the law. Anglo-Saxon jurisprudence of law has been evolved by the Western European colonial imperialists to trample upon us. But still it is being followed for whatever the reasons. The colonial masters have given that. So we had to search for certain issues, certain solutions beyond the parameters of the Anglo-Saxon jurisprudence of law. You will be wondering, what is the effect of Anglo-Saxon jurisprudence of law? In 1883, Calcutta Chief Justice called for a deity statue from a temple to be produced in the court. How can it be brought to the court? Surendranath Banerjee criticized it. He landed up in Contempt of Courts Act. One Bombay judge says that Krishna is immoral character. I'm not talking about spirituality, religion, etc. Anglo-Saxon jurisprudence has made the British frame the forest laws. Since time immemorial, tribals were the original sons of the forest. They looked after them, lived in the forest. These people made law in 1887 and they made all the tribals criminal. They alienated the tribals from the stuff. So for Anglo-Saxon jurisprudence people, forest and land are commodities. For us, it's a question of sustenance. We respect the nature. Prithvi, Mata, Bhumata we call it. See, this is how, why it evolved is Anglo-Saxon jurisprudence revolves around the concept of state nation. State is not Andhra, Karnataka, Tamil Nadu. State as in the constitution. They got a Westphalian state in 1883 in Germantown. They sat down and they prepared a concept of a state and a nation. Ours is not a state, king-based nation. Ours is a civilization nation. Our nationhood does not depend upon the king or the sword or the state. For example, I'll tell you how it comes. In 5th and 7th century, Chinese travelers came here and they said that there is one nation but there are 70 kingdoms. Remember? 70 kingdoms, they said that. So this is how they look at the nationhood. For example, our connectivity depends upon the culture. All of you must have known about Tyagaraja. Tyagaraja was an Andhra Pradesh man. They migrated to Tamil Nadu. When he was there, it was ruled by the Maratha kings. And his Tambura, etc. are now in Madurai under the Saurashtra Mahasabha from Gujarat people. So this is how, and what is the connection to Karnataka? His Samadhi was renovated, reconstructed, and everything done by Bengaluru Nagaratnamma. A Tyagaraja, a lyrics writer, connects Gujarat, Maharashtra, Karnataka, Andhra, Tamil Nadu. This is called the cultural connectivity. One British scholar says that the unity of India is not by a sword or a king or a power of a throne. It is connected by the footprints of the pilgrims. This is how our nation has to look at it. This is the reason why we have to get over the Anglo-Saxon jurisprudence, and Justice Nazir, who is from Karnataka, who came to Hyderabad, delivered a lecture on decolonization. Decolonization of the Indian jurisprudence is the need of the hour. And it depends upon the statutes, etc. And when we look at the Anglo-Saxon jurisprudence, etc., and implementation of the Harvard Law School of Thought, what do we land up in? Sabarimala judgment, or the cases arising out of man marrying a man, woman marrying a woman. So they are antithesis to the family system. Anglo-Saxon jurisprudence is the root cause for all these things. And to get over this, as students of law, we must be able to read comprehensively. All of us, let us remember, His Lordship said that read the biographies. Not only biographies, I'll just tell you something. The roots of Anglo-Saxon jurisprudence were in the a book written by James Mill. It is called History of British India. In that he writes that the Indians are barbaric, uncivilized, savage, lazy, greedy and filthy people. And that is a textbook which has been taught to the students for 200 years, even after independence. This is the root cause of the Anglo-Saxon jurisprudence and colonial masters trying to Ramesh out. To get over that, there are various written by Ramesh Chandra Dutt. Now, and how the colonial masters have destroyed the local cultures, etc. Amiya Lumba, Leela Gandhi, Annie Caesar, Albert Memmi, Bala Gangadhara, they wrote. All of us must know how the law has evolved, and Anglo-Saxon jurisprudence, which is a Western concept thrust upon us, and it is being interpreted in a wrong way to not fitting the society. So we have to take steps to see that we read much and interpret new laws in a new way. And I am sure that all of you will take a new path. And please remember, as American judge said, that when a lawyer refuses to stand between repressive state and a helpless citizen, when a lawyer refuses to stand, then that is the end of rule of law and beginning of anarchy. All of us discharge our social responsibilities, and I am sure that this gathering will embark upon and lead the way of decolonizing the Indian legal system. Thank you once again.
Thank you, sir. Now let us move to the most awaited segment of this evening, prize distribution. Now I request Mr. Devi Prasad, Student Coordinator of Moot Society, to announce the list of prizes to the winning teams.
Good evening to all respected dignitaries on the dais and off the dais. 2 days ago, every team walked into this institution as competitors. Today, they walk out as advocates, sharpened by argument, refined by pressure, and elevated by the spirit of justice that fills every moot court hall. And now, the moment every participant has been waiting for. Let us begin the prize distribution ceremony for the 3rd All India Moot Court Competition 2026. Our first award, the Abhimanyu Award. Our first award is the one award which is closest to heart of our institution, and Abhimanyu Award is not a consolation, it is a recognition. It goes to the speakers in the preliminary round who did not proceed to the semi-finals, but whose performance was so powerful, so passionate, and so precise that we could not let them leave this stage without honoring them. And I will list out the winners who are the 5 Abhimanyu awardees. And I request Honorable Mr. Justice E.S. Indiresh sir to hand over the awards to the winners. The Abhimanyu Award 1 goes to speaker number 1 from Team Siddhartha. Please give them a big round of applause. And Abhimanyu Award number 2 goes to speaker number 1 from Team Plava. Psychologists. And the Abhimanyu Award number 3 goes to speaker number 2 from Team Bhanu. Abhimanyu Award number 4 goes to speaker number 1 from Team Khara. Abhimanyu Award number 5 goes to speaker number 1 from Shubhakrit. Thank you so much, sir. And now we will move on to our next award. And I request Honorable Mr. Justice V. Srishananda sir to hand over the award to the winners. The award number 2, Best Researcher Award. And this award goes to researcher from Team Sharwari. That is SDM Law College, Mangalore. Best Researcher Award goes to researcher from Team Sharwari, SDM Law College, Mangalore. And our next award, Best Memorial. And the Best Memorial Award goes to Team Prabhava. Best Memorial Award goes to Team Prabhava. And that is 𝐾𝐶LU Law College, Hubli. Thank you so much, sir, and we will move on to next award. And I request Tyagaraja Inavalli, sir, to hand over the following prizes to the respective winners. And the next category of award is Best Female Mooter. And the Best Female Mooter award goes to speaker number 1 from Team Vibhava, Hafza from University Law College, Bangalore. And the Best Male Mooter award goes to speaker number 1, Vidit V from Team Jaya, and that is JSS Law College, Mysore. Ladies and gentlemen, we are now at very top of this competition, and that is the announcement of winners and runners. Firstly, we will announce the runners of the 3rd All India Competition 2026. That is Team Vibhava, University Law College, Bangalore. And I request all the dignitaries on the dais to hand over the prizes to the runners of this moot court competition. That is Vibhava, University Law College, Bangalore. Last one. Ladies and gentlemen, please rise for the champions of 3rd All India Moot Court Competition. That is Team Prabhava, Karnataka State Law University, Hubli. The cash prize for the winners and runners is sponsored by Kumari Vidya AS, Judge, Civil and JMFC, Udupi, and we will thank her for the continued support.
due to urgency, Honorable Mr. Justice Srishananda is leaving the program. Even Justice Honorable Mr. E.S. Indresh, sir. Moving forward, success of mega event like National Moot Court Competition is a result of collective effort. To organize the event of this magnitude requires the contribution of many. In recognition of the hidden hands who have worked day and night for the success of 3rd All India Level Moot Court Competition 2026, we are deeply honored to thank each and everyone. Now, I request the President of today's program, Sri Srinivas Murthikonda, to honor the mementos for the following persons. I invite Sri Manish K. Salwan, Manager, Legal HR and Operations, Celera Holdings LLC, upon the stage and receive the memento for his valuable guidance and continuous support extended to the organizing committee of the All India National Level Moot Court Competition. Thank you, sir. I also extend heartfelt thanks to Sri Manohar KB, Advocate and President of 3rd All India Level Moot Court Competition Core Committee, for guiding and supporting us. I request the President of today's program, Srinivas Murthikonda, to honor him with memento. Moving forward, now it is time to award the hard work, the research and advocacy skills of the participants. I would like to call each team to come forward and receive the participation certificate along with the college memento. I request Sri Srinivas Murthikonda to award the participation certificate and college memento. The team names as follows. Team Shubhakrut, please come forward. University Law College, Mysore. Team Akshaya, Siddhartha Law College. Team Raktakshi, Soundarya Law College, Bangalore. Team Kara, Saraswati Law College, Bangalore. Team Pingala, SJR Law College, Bangalore. Team Datri, MS Ramaya Law College. Team Prabhava, KSLU. Team Prabhava, KSLU Hubballi.
I request yes, 𝐿𝐻𝐶 to share his few words with us on the
I would request Rajashekar Ilyar sir.
Yes, Rajashekar Ilyar sir to share a few words with us on the
Team Vibhava, University Law College, Bangalore.
ಇರು ಅದು ಆಮೇಲೆ ಮಾಡೋಣ ಇದು ಆಮೇಲೆ ಮಾಡುವ ಇರು ಹೋಗ್ಬಿಟ್ಟು
Team Sharwari, SDM Law College, Mangalore.
Ask the audience to give big round of applause.
Audience, give a big round of applause to all the participants. Team Plava, Vivekananda Law College, Bangalore. Team Nala, GK Law College. Team Vikrama, BV Ballad Law College. Team Banu, CBR Law College, Shivamogga. Team Siddhartha, BMS Law College. Team Vijaya, Bhuvanajyoti Law College. Team Pramadi, Alvas Law College. Team Ananda, Vaikunta Baliga Law College. Team Shukla, Manvi Law College. Team Jaya, JSS Law College. Team Yuva, KVG Law College. Thank you, sir. Now I would request Sri Rajashekhar Hiliyar, Advocate, High Court of Karnataka, to share few words with the gathering.
Dignitaries on the dais, off the dais, advocate friends, my beloved principal Uday Krishna sir, and budding lawyers. It's a surprise. In the program schedule it is not mentioned. It's taken by surprise, but anyway, I take this opportunity to give one piece of advice to the next future generation or next generation lawyers. Take this profession by compassion. Don't take this profession by coincidence. If you work with compassion, rest of the things will be taken care by the profession itself. Or seniors and elders will take care of your dedication, your commitment to the profession. I have been asked to come today here to take felicitation on being appointed as member of Stock Witnesses Reforms Committee by Honorable Supreme Court of India. When Akshata and Dr. Ravindra sir called me and asked me to come, I said, I am the son of this institution, I am the product of this institution. Why you want to honor me? I'll come, I'll participate, but please don't honor me and put me into an embarrassing situation. Then Akshata madam and one name, Narsim Prasad, Advocate Puttur. Then I said, okay, if it is recognition, then I'll, or with this opportunity, whatever responsibility is bestowed on me now by the Honorable Apex Court of the country, I should remember, I should always, I told even when I had participated in Puttur Advocates Association program, whatever I am today is because of my seniors, my institution, that is this college and other colleges where I studied. I told the same thing even when I addressed my brother and sister advocates in Puttur Advocate Association. Whatever I am today is because of the freedom, independence and encouragement given by my seniors. Now this responsibility, whatever conferred on me, I should never forget Additional Solicitor General K.M. Nataraj sir, who has recognized me, chosen me and suggested my name to be a member of the committee, thinking that I will deliver something or I will give some inputs since I have the trial background. From this stage, I promise and assure whatever the responsibility what is cast on me, by keeping the belief and confidence in me, I will try to work hard. I will not let you down. I will give my 100% effort, and the confidence and the responsibility what Nataraj sir has given or trusted in me, I will try to work hard and try to maintain that particular confidence and the responsibility. I thank the college for having given me an opportunity to come here and speak a few words. While the Moot Court competition finals was going on, in fact, I was discussing with a few of my friends. If such competitions were to be held when I studied about 22 years back in this college, I have my own doubt whether I would have chosen to join the practicing career. The way in which, the manner in which the presiding officers posed questions, the manner in which they conducted the proceedings. Now, after completing 22 years of practice, I want to say one thing. This is moot court. This is not regular court. Regular court is something else. This moot court competition will give you more opportunity and encouragement to strengthen your knowledge, to upgrade yourself insofar as legal aspects are concerned. Don't get disturbed by the questions posed by the judicial officers or the presiding officers in the finals or in the competition itself. That itself is not the real court, but it is a stepping stone for your future life. As Justice Indrej sir told, whatever you are, first be an Indian. Wherever you go, whatever you achieve in your life, don't forget your motherland. Don't forget your roots, from where you have come up in your life. ನೀವು ತಲೆ ತಗ್ಗಿಸಿ ಕೆಲಸ ಮಾಡಿದರೆ ಮುಂದೆ ತಲೆ ಎತ್ತಿ ನಡೆಯುವಂತೆ ಆಗತ್ತೆ. So you just work hard, dedicate yourself to the profession. Rest of the things, system will take care. And the best example for that, as you know, last time also I told Sanmana athava publicity, I always try to avoid it. But since Ravindra sir and Akshata madam, Narsim Prasad told it is a recognition, I have accepted this invitation. I have come here. Whatever the responsibility is cast on me, I assure you, sir, I will try to give best, and I will try to bring some sort of recognition to the college also. Thank you one and all.
Thank you, sir. We have reached to the end of the program. Vote of thanks will be followed by Shanti Mantra and National Anthem. After vote of thanks, I request everybody to be seated for Shanti Mantra, later rise for National Anthem. Now I invite Srimati Subhashini J, Moot Court Society Faculty Coordinator, to propose the vote of thanks.
Good evening to all the esteemed dignitaries, respected members of the judiciary, learned advocates, faculty members, participants, students, members of the press, media, and distinguished guests gathered here today. It is my proud privilege to propose a vote of thanks for the valedictory ceremony of the 3rd All India Moot Court Competition 2026. First and foremost, I express our profound sense of gratitude to Honorable Mr. Justice E.S. Indiresh, Judge, High Court of Karnataka, for graciously delivering the valedictory address and for inspiring every aspiring advocate gathered here today with your Lordship's valuable words of wisdom and encouragement. Thank you, sir. I extend my heartfelt thanks to Honorable Mr. Justice V. Srishananda, Judge, High Court of Karnataka, in his absentia, whose esteemed presence added immense dignity and honor to this occasion. Thank you to sir. I also express our sincere gratitude to Honorable Mr. Justice Tyagaraja Narayana Inavali, Judge, High Court of Karnataka, Kalaburgi Bench, for honoring this event with your Lordship's gracious presence. Thank you, sir. I express my sincere thanks to Sri Srinivasa Murthikonda, Senior Advocate, Andhra Pradesh, National President of Akhila Bharatiya Adhivakta Parishad, and President of today's program. Thank you for your inspiring speech, sir. I extend my gratitude to Sri G. Jagannath Rai, President, Bar Association Puttur, for gracing this occasion. Thank you, sir. I extend my gratitude to Sri Rajshekhar Hiliyar, Advocate, High Court of Karnataka, and Honorable Member of the All India Stock Witness Reforms Expert Committee, Supreme Court of India, who is our proud alumnus, added a golden feather to the cap of Vivekananda Law College. Thank you, sir. I express my sincere thanks to Senior Advocate Shri Ram Mohan Rao, Advocate Puttur, who agreed to with us in the final proceedings. Thank you, sir. My sincere thanks to our core committee president, Shri Manohar KV, and secretary, Shri Shyam Prasad Kailar, and all the members of the core committee of the All India Moot Court Competition, whose tireless efforts, dedication, and commitment made this national event a grand success. I extend my sincere thanks to Shri Vivekananda KM, correspondent of our college governing council, for his constant encouragement, guidance, and support. Thank you, sir. I extend my sincere thanks to Dr. B.K. Ravindra, Director of Legal Studies, Vivekananda Law College, for his unwavering guidance and encouragement. Thank you, sir. I extend my warm thanks to our principal, Dr. Akshata AP, for her insights on organizing this mega event. Thank you, madam. I especially acknowledge the efforts of our team, Moot Society, and Srimati Sangeeta SM, fellow faculty coordinator and student coordinators, Mr. Devi Prasad, Mr. Dilip, Ms. Divya Das, Ms. Vaishnavi, for shouldering responsibility with me for the meticulous planning, constant coordination, and dedicated efforts. Thank you all. I express our sincere gratitude to Shri Manish K. Salin, Manager, Legal HR and Operations, Slera Holdings LLC, for his valuable guidance and continuous support extended to the organizing committee of the All India Moot Court Competition. Thank you, sir. I extend my heartfelt thanks to Shri Jagannivasa Rao, in his absentia, Advocate Puttur, for his generous support in arranging food services for all the 3 days of the competition. My sincere appreciation to Shri Govindaraja Sharma, Chief Warden of Vivekananda Hostel and Assistant Professor of Economics, in his absentia, for providing excellent hospitality and delicious food arrangements throughout the event. I also extend my gratitude to Hotel Aradhya for the comfortable accommodation arrangements made for all the participants during the competition. I also extend my sincere thanks to all the presiding officers who are with us in all rounds. Thank you all. Further, I take this opportunity to thank the Honorable Judges of the Taluk District Courts, Directors of Vivekananda Vidyavardhaka Sangha, members of the College Governing Councils, members of the Parent Teacher Association and Alumni Association, representatives of various bar associations, faculty members and non-teaching staffs, participants from different institutions, members of the press and media, and all distinguished guests gathered here today. Thank you. And I bow down for tireless work of various committee, faculty in charges and the students of Vivekananda Law College for the tireless works in these 3 days, day and night. Thank you, one and all. This proves the famous quote, unity is strength. And today we proved that. With a sincere gratitude to all great people who involved in this mega event, thank you one and all.
सर्वे भवन्तु सुखिनः सर्वे सन्तु निरामया सर्वे भद्राणि पश्यन्तु मा कश्चित् दुःखभाग् भवेत् ॐ शान्ति शान्ति शान्तिः
वन्दे मातरम् वन्दे मातरम् सुजलां सुफलां मलयज शीतलां शस्यश्यामलां मातरं वन्दे मातरम् शुभ्रज्योत्सनां पुलकितयामिनीं जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे